Convention on the Right of Persons with Disabilities. We saw a lot of progress, but it's very slow. That member states are not taking it seriously yet, and many steps still needs to be realized. And then we also will discuss a little bit that since 2024, the European Commission and several national governments has also been working toward the ratification of the Hague Convention of 2000 on the protection of adults, a pre-UN CRPD instrument that would enable the automatic recognition of guardianship, curatorship, and institutionalizing placement across borders. And that is completely opposite to what the convention wants. So today we really want to have an open dialogue because it is not progressing our human rights, it is regressing. So, and especially regressing in the right to legal capacity. Could this lead to a renewed expansion of substitute decision making? While we are really every time insisting that one of the pillars of independent living is supported decision making and having also access to justice. So without further ado, we will start today our conference and our first panel on using supported decision making. And then the first input will be the voice of self-advocates. So we will have different advocates who will explain from their perspective how it works for them and also what they do expect from policymakers. So without further ado, I'm glad to introduce you to Nicolas Joncourt. He is a board member of Enel Youth and also a person from Clear Autism. Nicolas, you have the floor, please.
Hello everyone, I am Nicolas Joncourt from Enel Youth Network, and I will talk about what supported decision-making means to me. I'm an AAC user, non-speaking autistic, from France, and I am studying for a master degree in sociology at the University Rennes 2. I want to specialize in disability studies. I'm 26, and I need full-time assistance. I communicate by writing on my iPad. For several years, I've been an activist for the rights for independent living. I am a member of Enel Youth Board. I'm also a member of the French Association Gaulle Autistes.
Sorry, we just have a small technical problem. We would like to visualize his PowerPoint.
Every day we wake up and wonder what we have for breakfast, what clothes do you want to wear, and what you're going to do in your free time. Then some days you need to make bigger decisions like where to live, with whom, to see a doctor, and how to spend your money. Do you know how many decisions make a single person every day? 35,000 a day. It means 2,000 an hour. Can you imagine not being able to make those decisions anymore? Hi, my name is Soufiane El Amrani. I'm a self-advocate who has been working at Inclusion Europe for 17 years. And when it comes to the right to decide, I always hear stories like this. I was under guardianship until the age of 25. If I was still under guardianship, I could not have gone to university. I would like to decide more things for myself and have a life like other people, to have support, people who explain to me so that I can understand and decide. These are the stories of some self-advocates. I myself have not voted since 2014 because I am under guardianship, and I feel bad because I feel like I do not have a say in something I care about. In many countries, people with intellectual disabilities cannot decide about their lives. Many still cannot have a bank account, choose a place to live, or own a house. Many are not allowed to get married. Many countries deny their right to vote. This is because people believe that it is dangerous for us to make our own decisions. This is also because we lack support to make decisions. So today, I want to speak about two things that are important when we speak about the right to decide. The first is the right to make mistakes, and the second is support for making decisions. So, First, the right to make mistakes. If you never make a mistake, you'll never stop and think, I could have done that differently. We reflect, we improve, we do better the next time. Isn't this reflection a normal part of life? A self-advocate and politician from Spain said, I learned by doing and making mistakes. It was not easy, but it has been worth it. We have the right to make mistakes, and people should not be afraid about it. Now, the second thing I'm going to talk to you about is support for making decisions. When you make a decision, don't you ask for opinions to your friends or family about what to buy, where to go. It is always good to get advice from others. Maybe you missed a detail. Maybe it helps you pick a better option. Getting support should not be seen as hard. It is just life. So why are people with intellectual disabilities not given the chance to ask for support? But you know, the good news, there have been some good new laws. Recently, many countries changed their law. This is the case for Ireland, Spain, and Germany. In these countries, the right to decide is respected and people get support to make decisions. If you're not living in these countries, you know what to do. You should push your government to allow people to make mistakes. You should ask your government to give support when making decisions. Remember, 35,000 decisions a day. This is what it means to live your life. Each one of them belong to you, not your guardian, not a judge, not a system, to you. So stop talking about whether people with intellectual disability can decide. Let's make sure they get to decide. Thank you.
Thank you very much, Sofiane. Very clear and concise. Did you find the PowerPoint of Nicholas? Okay, we can go back to you, Nicholas. Please, the floor is yours.
What supported decision making means to me. I'm an AAC user, non-speaking autistic, from France, and I am studying for a master degree in sociology at the University Rennes 2. I want to specialize in disability studies. I'm 26, and I need full-time assistance. I communicate by writing on my iPad. For several years, I've been an activist for the rights for independent living. I am a member of Enel Youth Board. I'm also a member of the French Association Autisme. France ratified the International Convention on the Rights of Persons with Disabilities in 2010, but its implementation remains a challenge, particularly with regard to deinstitutionalization and legal capacity, Articles 19 and 12. Non-speaking autistic people with high needs are significantly impacted in their right to self-determination. They are placed under guardianship and institutionalized. I was educated in a mainstream environment and by correspondence, and I had alternative communication devices very early on. This has allowed me to express my choices, to be able to make decisions and to have knowledge about the world. This gives me control over my life. But this is not the destiny of the majority of disabled children, especially non-speaking autistic people who are institutionalized, with little or no schooling. In addition to the lack of respect for the right to education and the right to communication, personal assistance is not very accessible, especially in the case of cognitive disabilities. Slide 4. The power to take control of one's own life is the most important thing for an individual, yet some are deprived of this resource not through a lack of will or illogicality, but because it has been denied to them. The ability to shape one's own destiny is undoubtedly what distinguishes contemporary societies from traditional societies or dictatorships. Even today, however, the laws of many countries, even in Europe, continue to deny people the right to decide their own destiny. The ability to make use of the support of my family environment enabled me to find my place in society at a very early age. Slide 5. I was not silenced but educated on topics concerning emancipation and the search for lessons of life lost due to stigmatization and exclusion. Year after year, I was equipped with the tools to exercise my ability to decide my own life, from using AAC tools to embracing the ideas of neurodiversity. Slide 6. I did indeed grow up in an environment of strong political engagement, thanks to my parents, both of whom came from left-wing families, and my paternal grandfather. My parents have long been committed to causes such as social justice. Ever since I was very young, I have taken part in demonstrations with them. I come from a family of activists spanning several generations. From my paternal grandfather, ACGT, General Confederation of Labor, trade unionist, I care deeply about my family history. My paternal grandfather was very committed to the idea of public service and the values of the NCR, the National Council of the Resistance, which led to significant social reforms after World War II, including the creation of Social Security. He was active in the CGT until the end of his life. To my cousin on my mother's side, who is active in a very progressive student union, and including my father, a libertarian activist. Virtually all the members of my family are trade union or political activists. I am the only believer in the family. I am nevertheless happy to be part of this community with humanist values that I share. Slide 7. Having been personally touched and made aware of disability-related discrimination from a very early age, I became interested in the Holocaust at the age of 10. And in particular in Action T4, the Nazis' extermination of people with disabilities. I talk about this in my blog, which I started at the age of 10. As a child and young teenager, I was then planning to study history. Slide 8. I currently live in a university residence, with personal assistants for 5 years now. These personal assistants take turns at various times of the week to accompany me. Slide 9. I'm autistic and dyspraxic. This makes it difficult for me to plan and initiate motor movements. My PIs help me in my daily life. They are a bit like private secretaries. They help me to do research on internet, to turn the pages of a book I want to leaf through, to find programs that interest me, and accompany me in my associative activities, to manage my mailbox, to prepare conferences. But I always choose what I want to do and how I want it to be done. My parents help me with the administrative formalities. I delegate the management of certain activities using proxy, with total supervision on it. They assist me during job interviews for personal assistance, and for the training and the management, but in the end I decide who I want to take on as a personal assistant. As I have difficulties with fine motor skills, I find it difficult to use a computer mouse or a trackball. Touch screens also require precision. That is why I need help with formalities and administrative procedures. But I am in control of and make all decisions regarding my life, such as my budget and the management of my bank account. I was given a bank card at the age of 13 linked to my youth bank account, so I was able to manage my money with help from quite an early age. If I have an appointment with my bank advisor, I am accompanied, as always, but I am the one who leads the discussion and makes my choices regarding specific products or transactions. I manage my own schedule, just like anyone else. I have tools such as printed timetables, which my personal assistants fill in based on my appointments, my lessons, and my other activities. My family and my personal assistants often give me advice. I can take it on board, or not, just like everyone else. Slide 10. People believe that the involuntary movements and sounds I make, which are part of my disability, and the fact that I cannot express myself verbally, make me impossible to have opinions. Yet I have passed my baccalaureate and am currently studying sociology. Most of the time, I am not seen as a capable person but as a strange creature with no access to the outside world. To neurotypical people, the very fact that I can express myself by typing on my computer keyboard or my iPad seems impossible. Most people see me as someone who doesn't understand what is being said to them. People often talk to me like I am 3 years old or about me in the third person as if I weren't there, and they tend to address my personal assistants instead, even though I am able to communicate. I am aware that most people still perceive me as a being devoid of any intelligence, any understanding of others, or even any form of thought or desire. Slide 11. My master thesis is on the representations of medico-social professionals on the right to vote of people under guardianship living in institutions, a right granted in 2019, in the context of a transformation of medico-social services, which I analyze in light of the convention. The findings show that the health and social care sector remains largely structured around a medical and paternalistic model, reinforced by deeply ingrained family and professional attitudes, a lack of understanding of the convention, a failure to move away from institutionalization, and resistance to change practices. There is a presumption of incapacity regarding a certain section of the population. The transition away from institutionalization seems a long way off. Deinstitutionalization is not held out as a prospect, but rather a fair institution that guarantees the rights of institutionalized people. The plight of the most vulnerable is always highlighted to justify institutionalization and legal protection measures. Slide 12. At a time when the far right is on the rise, a movement known for its scant regard for people with disabilities attitudes and political responsibilities must rapidly shift towards a human rights-based approach. Ableism in society and neoliberal choices to cut social policy budgets, underpinned by the idea of a hierarchy of lives as seen in the debate on end-of-life care, can lead to a dangerous and fatal situation for people with disabilities. The present weighs heavily on me, leading me towards an uncertain future. I am deeply anxious at the thought of ending up in an institution after my parents have passed away. Slide 13. Thank you for your attention and for helping to change attitudes.
Thank you very much, merci. Yeah, you have no words. It comes from self-advocate, so it's very strong and it's clear enough how important it is. No doubt, for the decision-making, he would be definitely, segregated in a corner. So thank you for sharing this with us. So without further ado, we go to online. We have a participant, Simon Johansson, online, and Agneta Sherman. They are from Young Personalized Assistant Organization. You have the floor now.
Thank you very much for inviting us to come and speak about this thoroughly urgent and crucial topic, right to legal capacity. My name is Agneta Sherman, and I'm the operations manager for Equal, which is a knowledge hub of YAG. Joining me is Simon Johansson, and he's both legal representatives, Josefin Roxell and Lillemor Johansson. Before I hand over the floor to Simon to tell us how he makes use of the right to make decisions with the help of support, I will say a few words about the National Association YAG and Independent Living, and about our knowledge hub Equal and our project I Decide. And my pictures, maybe. I go on. The National Association YAG is an independent living organization made up of people with extensive disabilities who need support in decision-making also due to intellectual disabilities, and it was founded in 1992. The most important core issue for JAG is the right to have personal assistance. JAG's members know from experience how important it is to be able to express one's will in one's own way to the person who is expected to support you in making decisions. The rights set out in Article 12 of the CRPD are clearly linked to the possibility of having the rights under Article 19 fulfilled, namely the right to live a free life in the community with individually tailored support. Bild 3 är jag på, om det går.
Nu är det 3.
Jag ser alla samtidigt. Okay, Equal is working against IQ discrimination in all its forms. We are all equal and have the same value as all other people, regardless of what IQ we have or how smart we are. No one should be discriminated against because of intellectual disability. Being deprived of the right to decide for yourself or not having the support you need respected is not only a violation of the CRPD, it's
Hey, Aneta, you are muted. We don't hear you. You need to unmute.
Ja, nu. Nu är du inte det.
okay. You haven't heard anything?
Now we hear you.
Oh,
No, we heard everything. We just lost you like 20 seconds.
okay, good. Thank you. I got nervous. Okay. We applied for and been granted funds from the Swedish Inheritance Fund, Allmänna arvsfonden, it's called in Swedish. And we want to increase the knowledge about what the conditions look like and about how it works in practice for people with the most extensive support needs to decide for themselves. And the aims for the project is to make it easier for individuals, but also to help Sweden to live up to its obligations according to the CRPD. What is unique about the project and what we do is that we ask persons with extensive impairments themselves to tell us how they make decisions. No matter how people communicate or what help they need and support, we listen and we will learn from them. The system and the law can always be improved, but we believe that the Swedish system med god man, legal representatives, provides the necessary requirements to realize supported decision making. A good man, a legal representative, may be tasked with looking after the person's personal affairs, managing the person's financial affairs, and safeguarding the person's rights. The role must be adapted to each person's needs. And now, Simon, it's your turn to tell about how you go about making both small and large decisions.
I think you are muted. We don't hear anything. I don't think we can hear anything yet.
Så.
No, it's okay.
Yes. Yeah. We will do it without pictures.
Hello. Thanks for the invitation. My name is Simon. I am 36 years old, and I live in Stockholm, the capital of Sweden. I have multiple disabilities and use many assistive devices. My personal assistant is one of them. I have two legal representatives, my mother Lilima and Josephine. They are my very important decision support.
Yes, Simon, as an adult, you have the right to have a representative, and you actually have two. It's me, Josephine, who watches over your rights and helps you with your finances, and your mother, Lillemor, who makes sure you have a good living condition and a good place to live. Both of us make sure that the assistants and other care are working.
My family gave me the support I needed when I grew up. It was natural for me to choose a parent as the first representative in contact with authorities and others.
Yes, Simon, in your family, you have always had a voice, even without being able to speak. You have been someone who counts, and you have had the same rights as your brothers. Personal assistance from the age of 9 helped you to maintain and develop this outside the family. And this has built up and strengthened your preferences and your will.
I want to choose by myself what, when, how, and with whom. No one should ever be able to force me.
Nej, sorry.
Legal capacity is the key to freedom, and give me the opportunity to break free. I have chosen people who know me well, know my story and preferences, and they can communicate with me.
Yeah, the right to legal capacity is important to you because legal capacity is necessary for self-determination, which is the basic of human rights. No one should be able or allowed to force you. Your mother has been your legal representative for almost 20 years, but you two have talked many times about the fact that it can't be like that forever.
No, and of course you, Simon, want a new representative with knowledge of what it means to have to live with a disability and with personal assistance. And after many years with the JAG Association, you have come to know several people with such knowledge. But the most important thing for you, Simon, is that the new representative is also a person you can communicate with. And so you have chosen to ask Josephine to be your your new and your next legal representative. And fortunately, Josephine has also chosen to accept that assignment. Simon.
We share information in a common digital calendar. The notes are color-coded.
Yeah, we share information digitally in a group calendar. Your assistants write what and how you experience your day. Confirmed and planned activities and wishes are noted. The two of us, me and Lillemor, share important meetings and commitments in the calendar. We also place tickets and travel information there. And yes, everything is color coded.
We also make video calls. My assistants may help me with some communication that needs spoken words.
Yeah. And you skipped one, yeah. But for the colors in the calendar, blue is for diary notes. Red means must not be changed or forgotten. Yellow means preliminary needs to be supplemented. And green means agreed, just do it.
It's just like the traffic lights.
Yeah.
Easy to remember. That's it.
A lot of written information about me and my background is collected with pictures in a kind of instruction manual. I want and I need to ensure the quality of my life. I expect my representatives to take care of that.
Yes, it's important, very important, that the new assistants learn from the written information when they have their introduction. But they also learn through practical information, working together side by side with someone of your assistants who is used to it. And they do that for about 60 hours.
This gives you, Simon, the influence over your everyday life, and the assistant gets your habits and choice are respected, and routines are maintained, which is important to you. It is quality assurance, and we, you, me and your mother, are responsible to keeping the information updated in cooperation with the supervisor for the assistance of course.
And when changing representatives, as we do now, there is a risk that some of the knowledge about Simon is get lost. He may then suffer from a lack of insight and be exposed to expert opinions, and this can affect his quality of life and self-determination. Simon, both you and I are sure, and we think that the most important thing with a representative is to be reliable and committed. Then your life will continue being as good as it is now. So, thank you.
Thank you for listening. Thank you for listening.
Are we going to show the film? Or
Yeah, we have a
is it
short video that we would like to share.
If it's possible.
Yeah, I think so.
Och du ska fortsätta ha en god man som hjälper till. En god man som känner dig väl och vet vad du vill och hur du vill ha det.
Att välja och att bestämma själv.
Precis, och då kan ju du få välja.
Mamma.
Ja, precis, att mamma som är god man nu. Men om du vill ha en till god man.
Att fatta beslut.
Ja, precis.
Hjälper till.
Exakt, god man hjälper till. Vem skulle du vilja ha som god man som hjälper till och hjälper dig fatta beslut och så?
Josefin.
Vill du ha Josefin som god man?
Josefin.
Ja eller nej? Ja. Ja.
No, mikrofon.
Thank you.
Thank
Thank you
you.
from Sweden.
Thank you so much.
Okay, thank you very much. Sorry for those with sight impairment who couldn't see the movie, but we will send you definitely later on through a link, YouTube, where we will have the description of what has been showed to the rest of the audience. So my apologies. So without further ado, we go to the next speaker. Thank you, Simon and Agenta. We will go to the next speaker, who is Jan Diegroof. The floor is yours, and you have 10 minutes.
One moment. I think she wants. Tell me, you want to lie down? No. So she prepared a talk, and I will read it out loud. Johnny? Here. Johnny. Thank you for inviting me. I'm 36 years old, and as I have a master in European and international human rights law, I will start with the European Convention of Human Rights. Article 10 is freedom of expression. Everyone has the right to freedom of expression. This right shall include freedom to hold opinions, to receive and impart information, ideas, without interference by public authority, regardless of frontiers. Article 14, prohibition of discrimination. The enjoyment of the rights and freedoms set forth in this convention shall be secured without discrimination on any ground such as sex, race, color, language, religion, political or other opinion, national or social origin associated with the national minority, property, birth or other status. These two articles mean that the right to make your own decisions is a human right and cannot be ignored because of disability. This means also that society must give the necessary support to enable each person to give their opinion on anything they want to decide upon. When these rights are violated, then you have Article 13, and that is the right to an effective remedy, meaning that you can go to court when your rights are violated. Now I would like to tell you about my own experiences. I don't want to offend anyone, but my legal capacity on financial affairs has been taken away from me. That happened for several reasons. I cannot talk and not use my body very well. For instance, I cannot draw my signature or operate my computer independently. Therefore, I can never sign up for a purchase myself or open a bank account. I cannot do a lot of things, but that can never be a reason to take away my right, not even if it is offered in the name of my protection. I have experienced discrimination. Often I am not taken seriously. When I arrive somewhere, I am not spoken to. It means they regard me as not fully capable. I do want to be taken seriously, so people must involve me with whatever concerns me. It would help if the Dutch law recognizes my right, and if the Dutch law would oblige everyone to always ask me what I want. This does happen in daily practice, because my family makes sure this happens. I feel protected by my family. Years ago, I bought a house. I really wanted to live in my own house independently and not with my parents. This could be realized because my mother's arranged the finances. The notary found I am disabled, and she wanted to establish that I can decide for myself and that I could express my will independently. She came to visit me. It was a pleasant conversation, but strange nonetheless. I did not know what the outcome of the conversation depended on. She was the judge on me, or on my way of supported communication. If I want to move out of my house into another one, I will need the permission of the court. It makes me uncertain again. How will the court view me and my decision? I am often viewed upon as incapable of thinking. It matters therefore that I am recognized as someone who can decide for myself, even if I make bad decisions. No one is to judge my capability. If not, then my rights as a person is not recognized. The UN committee was right when they held on to the decision to allow only supported decision making and not substituted decision making. In the Netherlands, that view is not supported yet, but I hope it will someday. Thank you.
Thank you very much. Tiandi and Jose for sharing with us your struggle. And so we hear now from people who are lived experience what it is if other people take it over and how it shouldn't be. So now the second, I will thank the first panel for your intervention. Maybe we can upload them before we go to this next panel. Thank you very much. So the second panel will be about applying supported decision-making. We'll have some insights from supporters and also some clarification about legal capacity reforms. So the first speakers that we have with us is Marine Uldry from the European Disability Forum. She's with us online. Yes. So please, Marine, you have the floor.
Yes, good afternoon, everyone. Thank you very much for the invitation to join the event. And unfortunately, I could not make it in person, but I appreciate the opportunity to present online. So just one moment until I fix the presentation. Yes, you should be able to see it on your screen. So what I'm planning to do in those 10 minutes is to give you information about where we are at concerning supported decision-making regime across Europe, and some recommendation that we have from the European Disability Forum. So for the participants who don't know us, at the European Disability Forum, we do advocacy at the level of the European Union, and we represent people with all types of disabilities. 2 years ago, in 2024, we did a research to look at what is the state of play of legal capacity and the right to choose in Europe. So what we did is that we look at all the EU countries to sort of evaluate where we are when it comes to support. I'll post the link in the chat and can be sent to you afterwards. But what we found was that since the UN Convention was adopted, there have been reforms in many EU countries, but no EU countries as of today fully ensure the right to choose and support persons with disabilities in all their diversity. So people with all types of disabilities. Sometimes I'm trying to be more positive about reform, but today I feel a bit less optimistic, a bit more negative. So I have a more negative tone. But what we found was that only 6 countries have almost fully removed substituted decision-making, which is actually very few countries when we think that it's been many years that the UN Convention was adopted. We also found that only a bit less than half of the EU countries have established supported decision-making in law. So highlighting progress, but also highlighting how disappointed it can be to see that not even half of the EU countries have actually support for people. On the screen, I'm showing a map of the countries that have adopted supported decision-making in their law. So there are 13 countries across Europe. It doesn't mean that the systems are perfect in those countries. So sometimes, and I will explain afterwards, it's only concerns specific decisions, specific measure. Sometimes we have systems that exist in the law, but actually in practice it doesn't work. But it is a beginning of information that we have. We heard from Soufiane at the beginning that we all make many decisions during our days. I think he mentioned 35,000 decisions in one day. And of course, when we hear this, we know that supported decision-making is just to help people who want it or who need it to make some of those decisions. So it's never to decide on everything. Like we also heard from other speakers, like Nicola actually can perfectly make decision, but it's about the support needed to sometimes like understand, make the decision, or sometimes actually to defend those decisions. And I think that's something that we see more and more, is that actually support person, they are the outside person who supports and put forward the decision, so it is actually respected. This system of supported decision making also coexists and is part of broader legal capacity regime in the EU. I mentioned that only 6 countries have made big progress to almost align with the UN Convention. And I think it's important to know that in several countries, you can both have supported decision making in law, but you also have law that also allow to completely remove the legal capacity from people. So we have 2 systems that still coexist, and this is also a problem. So yes, in summary, we have different support systems that exist in law and in practice. I showed the one that exists in law, but also in some countries, you might have development in practice that are not reflecting in our map. So it can be pilot projects, smaller projects in a region. That can also be a good start, but we also need definitely change then in the law. I just mentioned it, but many support systems coexist with substituted decision making, and this is a problem because sometimes the court or legal guardian will go for substitution instead of support. So it would be better to have support system only and to really put an end to substituted decision making. So that's what we really advocate for. In some support systems are also not available to all. So when we did the report, when we look at Sweden at that time, the Goodman, the support person, was mostly available for people with psychosocial disabilities. I think it's great to have heard from Simon about how currently receiving support and how that might evolve also to support more people. But that's really important that support is available to everyone, independently of their type of disability and the type of support that they might need. What we also found was that some support systems are also great on paper, but on paper only. So in reality, changes are not applied. And that's what we found in Portugal. So you might have something that exists in the law, but it doesn't exist in practice. And that's something that is very concerning. And we need to ensure that lawyers, courts, everyone understand the change in the law and make it a reality. And what we found as well when it comes to legal capacity is that some good development actually slowed down by constitutional issues. So for example, in Lithuania, they tried to make big change in the law. And actually, because the constitution say that it's okay for some people to have their rights removed, so for example, the right to vote, to be able to make real change, they will need to reform their constitution. So that's a legal issue that's really slowed down progress in reality. What we need in EU countries is really a clear supported decision making system established by law. So we still believe that legal changes is important, and that should apply to all people, like everyone. Actually, we believe that it should apply really not just to people who have a disability, but broadly to anyone who need at some point in their life support. That's important that it is in the law because it creates legal certainty when it's not in the law, if, for example, the government change, then the government could decide also to remove this. So it needs to be established by law and be sustainable in time. We also need to promote existing measures that help to support people's decision and the will and preference of the person, like it is established under the UN Convention. So you might have heard about power of representation, which is advanced decision that people might make, for example, through a power of attorney or another legal instrument where you say, well, if I'm in the coma, or if I'm really sick, or if I'm in a specific situation, I want this person to represent me or to make decision for me. So in the case that you know that you trust that person and you know that that person will respect your will and preference. So it's for a decision that you make for the future. Those are useful instrument actually that aligns with this decision, this autonomy and will of preference. Sometimes they are underused, but also they don't exist in all EU countries. So in our report, we found that there is 9 EU countries that do not have power of representation, but where they exist, then could be more used. We also need to end once and for all substituted decision making. So it's broader discussion about the change of law. And we also need a mid and long-term strategy to ensure legal capacity and provide support. So really have a holistic and practical approach. Many decisions people are making, and it's in many areas. So sometimes you see changes in the law when it comes to decision for daily life, but then that does not apply to medical decision. So you might still see people being forced in mental health hospitals if they experience mental health crisis, or still see people being forcibly sterilized or receive contraceptive against their will. Or you might also see them having the right to vote removed. So it's really having an holistic, a global approach to support and decision. And of course, looking at what worked well in different countries, really to putting people first. And that's exactly what Enil did in having a self-advocate expressing what support means to them and how important it is. And that's what politicians needs to do. So we need real political will, consistent and holistic. We need them to understand the UN Convention, the CRPD, so what support means, what will and preference is, and also the best interpretation of the will and preference. Because politicians will always say, oh, there are difficult cases, we don't know how to deal with them. And instead of speaking with self-advocate, with people who went through those situations, they will just think that this is not possible. So they need to understand the CRPD, and they need to hear from people directly. So that leads me to the third point, co-developed changes. So putting the voice and choice of people first, and developing law directly with the people that are affected. So with all of us. More than changing the law, we need to change mindsets. And I think it's really great to have this conversation, and that we continue to have those conversations and to have more people than just the disability movement involved. And we also need to, of course, to then make those changes practical. So we always call government to ensure that those legal changes are accompanied by funding and training. So to translate the text into the reality. And I think with a so good example, also with support from family members and support person on how this is happening. And then my last slide of what we need from the European Union, because as I mentioned, EDF, we work at the EU level. We need the will, we need the way, and we need the money. So the will is really the willingness to comply with the CRPD and to lead by example. At the moment, at the European Union, there are discussions on a new law on protection of adults in cross-border situation. And the law was prepared in a way that does not align with the UN Convention. This must be amended. We work really actively on this, also together with ENIL and to many partners to bring changes to this law, and also some EU member states also align with us. But what we see from that law is that the will is not really there. I mean, we have like good people also in the EU, but there are really people who do not want to comply with the CRPD, who do not understand the CRPD. So that's a change, like the will is very important. Then the way, we also need the EU to show the direction to EU countries. So we've been calling for EU guidance, EU recommendation on supported decision making that would help EU countries to make changes in practice. And those recommendations should, of course, be prepared with the disability movement. They could also to show the way organize peer exchange and learning between countries, so they could bring somehow to change the law and implement new policies. And I know that the next speakers will also give some example on how it's done in the countries. And then lastly, the MOLI is always important. So the EU also can fund projects on supported decision making. So that's what we always say. Please put the money where actually we can have important, long-lasting changes. Stop funding institutions, stop funding things that actually deny people to exercise their rights, and use that money instead to look at pilot projects to fund support or already existing system that require money to be extended to more people. So those are our recommendations. I will stop here, and thank you very much again for the invitation.
Thank you very much, Maureen, for sharing with us the perspective of the European Disability Forum. And I hope that we will overpass goodwill. It's 20 years after the CRPD. I hope that we will go to engagement, and that all the next money, the next multi-financial framework will screen the money where it goes to, and it will be CRPD compliant. So thank you very much, Maureen. So without further ado, we go now to those who give support to the decision makers. So we have you, Dan, with us from the National Autistic Task Force, UA-UCAP. We are very happy to have you with us. So without further ado, just highlight a little bit for how this support and decision making can voice the will and the preference of persons with disabilities themselves. Okay, that's good.
Although I do apologise for not being able to be there in person, I hope this recording will suffice. I just want to start out by explaining a bit about who the National Autistic Task Force are. We're a UK-wide autistic-led organisation. Our focus is bringing autistic voice into issues which affect autistic people who are less able to directly advocate on their own behalf. This very much includes a focus on furthering the rights of autistic adults whose capacity to take their own decisions may be questioned. The NAT is not a representative organisation, but rather an autistic-led organisation with a specific focus. And the directors of the NAT are all autistic people with a mix of personal and professional expertise in areas relevant to the NAT's work. We're also an associate member of UCAP, the European Council of Autistic People. So that's who I am. My name is Yo, and I've been involved in the autistic community in the UK for more than 20 years. I'm autistic. I have family members who are autistic, and I have both personal and professional knowledge in this field. In my day job, my professional role is as an independent trainer and consultant in English law, both in areas involving support and protection of disabled and older adults, including the law around legal capacity in England. I primarily work for local government organisations in England, teaching the law to social workers. And in my spare time, I'm the strategic lead of the NAT. I also sit as a NAT representative on the National Metacapacity Forum in England, which is a government body which works to improve understanding and implementation of the law in England, and works hard to further good supported decision making and maximise autonomy for people who may struggle at times with making their own decisions. So I want to just provide a brief overview of the situation in the UK before I talk about the NAT's work and position. The situation around legal capacity in the UK is complicated by the legal reality that the UK is not one but four nations. And Scotland in particular has a very different legal picture around legal capacity. Whereas England and Wales, the law is the same, and the law in Northern Ireland is very similar to that in England and Wales. So in Scotland, the law provides for guardianship involving a loss of legal capacity that can be in the area of welfare or around money or both. That is not specific to individual decisions, but a blanket affair. The law in Scotland also allows for a welfare attorney to be appointed by the person themselves for them to say who they want to represent them. In 2025, there were around 20,000 individuals in Scotland subject to a guardianship order, and slightly over half of those are people with learning disabilities, including, of course, many autistic people. Around a third are older individuals with dementia. In Scotland, the law has principles that any intervention must be for the adult's benefit and must be the least restrictive option. It provides that the wishes and feelings of the person must be taken into account, but definitely are not determinative. And the law says that people supporting the individual or protecting them must encourage the person to develop new skills in making decisions. However, that's often not remotely realised in reality, and in reality, once guardians are appointed, guardians will tend to generally do what they think is best for the person, full substitute decision making, and there is very little accountability for guardians after they are appointed. In England and Wales, and indeed in Northern Ireland, things are slightly better. Capacity in English law is time and decision specific. There is no blanket deprivation of legal capacity. The test is supposed to be applied to each individual decision. And there are principles in the law that say that adults should be presumed to have capacity, that they are not required to prove they do. There's an explicit principle in the law that requires supported decision making, that all practical steps should be taken to support adults to make their own decisions, and also provision in the law that explicitly states that adults shouldn't be judged to lack capacity just because they make a decision that other people disagree with or think is unwise. It's also possible in English law to have a representative, an attorney chosen by the adult themselves. It is, however, also possible for a deputy to be appointed or someone by the Court of Protection. But even then, that is not an equivalent of guardianship. It is supposed to be decision specific, and the deputy is only empowered to take decisions where for that particular decision the adult is unable to take their own decision. And in English law, deputyship for welfare as opposed to financial matters is quite rare, because the law explicitly recognises the risk of that to autonomy and discourages the court from appointing welfare deputies, preferring that whenever possible, decisions should be considered on an individual decision basis. However, things are not all fantastic in England and Wales. Research and other evidence demonstrates that in practice, capacity decisions are often very heavily led by people's diagnosis, and blanket presumptions are made that people lack capacity for all decision making. For many individuals with learning disabilities, those who are perceived as more severe. So it's also inevitably the case that decisions which are seen by professionals as unwise by adults with disabilities tend to lead to slipping into conclusions that the person lacks capacity. So in practice, things are not fantastic and still have a long way to go. But there are definitely some good things about the system in England. Court of Protection judges and the law itself are really very strong and clear about the importance of autonomy and rights and the importance of good supported decision making. But that isn't always realised in practice, especially where decisions are made where the court is not involved. That said, there are many very committed and dedicated legal professionals and social workers who passionately believe in autonomy and rights and are very interested in doing really good supported decision making and maximising people's autonomy and ability to take their own decisions. So that's the context locally in which the NAT is working. The right to legal capacity is a complex issue, and the NAT is still in the process of developing a full position on the right to legal capacity. But I can tell you that we are absolutely passionate about promoting the importance of autonomy for autistic people and people with disabilities more broadly, and encouraging progress to improve support for decision making and to educate and encourage providers and those supporting individuals, including family members, to do far more to support people's ability to take their own decisions, to develop the decision-making skills of children and young persons with disabilities, to provide good support for people to take their own decisions. We have published the National Autistic Task Force Guide to Quality Care and Support for Autistic People, which is available both in English and Portuguese, and that very much advocates for the importance of high quality support for communication, the development of communication adaptations, and the maximization of an individual's ability to communicate and take their own decisions. We absolutely stand with and support the fight of organisations in countries in Europe which still have legal provisions that allow for the blanket deprivation of legal capacity on the grounds of disability, and we very much support and want to further the fight against such laws. We are also very dedicated to trying to challenge and argue against the detention of disabled people, autistic people in particular, because of our focus in inappropriate institutions, both in the UK and elsewhere in the world. We're very keen to work collaboratively with other organisations to further rights and progress in this area, but also to engage in constructive discussions about how it is possible to move further towards compliance with the UNCRPD throughout Europe and beyond. That said, however, we do recognise that there are some complex ethical and legal challenges to resolve in realising rights to legal capacity, and we're keen to engage in constructive and pragmatic discussions about how rights and autonomy can be furthered in ways that will work and can be carried forward effectively in the real world. So we're very appreciative to be asked to speak at this event, and wish all of you a very constructive event and good discussions about the way forward across Europe. Thank you very much.
Okay, thank you then. So we had an insight now from how support can be given. So the next intervention will be from a government side. So we will have with us Dr. Alistair de Gaientano, sorry. He's the legal and policy advisor of the Directorate for the Disability Issues of the Government of Malta. And he will explain a little bit for us how the reform on capacity, legal capacity is going on in Malta. Please, Alistair, the floor is yours. You have your 10 minutes, please. Is he with us? Okay.
Yes, thank you. So I will share a PowerPoint on screen. Just give me 1 second, please. Voila, 1 second. Okay, so I'm sharing my screen now. Share. Okay. Can you see my screen?
It's loading. Yes. You just need to make it full screen.
Okay, is it good like this way?
I mean, it's better. This is perfect, yes.
Perfect. Okay, so thank you. So what I will do is this. I will speak about Malta's journey when it comes to implementing Article 12 of the UN Convention, and also implementing supported decision making. And then also, since I was asked by Enel, I would like to touch on some elements relating to challenges which we found on a practical level, and also link in with the European dimension and the international dimension. Like colleagues before mentioned, for example, the UN Convention, and also like the Hague Convention, and like efforts at EU level. And to the extent possible, I will also speak about how Malta's efforts also aim at linking in with this. So first of all, I wanted to mention that like after years of work, just a couple of weeks ago, the Maltese Parliament adopted the Personal Autonomy Act. So with the Personal Autonomy Act, its aim is to put in place a plan to be able to shift from a substituted decision-making system, so basically interdiction and incapacitation, which was given by the courts, and also guardianship, which was given by a specific board, to a system of supported decision-making, which there will still be structures in place. However, at the end of the day, the main consideration will be the will and preferences of a person, while also providing for a best interpretation of such will and preferences when it is not practicable to obtain such will and preferences. So, for example, as a model, one could look at Ireland's legislation, where there is a decision support service and a legal structure under their legislation, which was put into place as from 2015. And we tried to work on a similar system.
I'm sorry,
So,
Alistair,
yes.
I think if you are changing slides, we don't see that.
No, I'm not changing slides. Just
Okay,
giving
I'm sorry.
a bit of a general introduction,
sorry.
and then I will go to specific things. But basically, yes. So this is the main piece of legislation here that we adopted. So with the legislation, it emerges also from our legal obligation. In 2012, once we ratified the UN Convention, there's Article 12, which I will not go into because a number of other speakers have mentioned that already, like in the past, so in previous presentations. So the aim is to have a system that addresses local needs, while on the other hand is compliant with the UN Convention. So in 2012, at the same time that the UN Convention was ratified by Malta, an umbrella act called the Guardianship Act was introduced, because at the time the only options available were if a person needed support with decision making, was to have a decree issued by the courts that would appoint a curator. So either interdiction, which meant that there was total substitution in all acts of civil life, or else incapacitation, which was substitution on select grounds. And then you also had a reference to this in the Mental Health Act, interdiction and incapacitation, and they had a concept of a responsible carer there. However, anyone who was a mental health, within the remit of the Mental Health Act, could not even get access to guardianship. So if you were subject to the Mental Health Act, you could only get a curator from the courts, even following 2012. Otherwise, if you're not under the Mental Health Act, you could get also a guardian after 2012. But this was still not in line with Article 12 of the Convention. So the efforts over the past years were to remedy this situation. The current government had made a pledge also to adopt legislation implementing Article 12 in its manifesto. So the current legislature started in 2022, and just at the end of this legislature, actually, because Parliament was dissolved at the end of April, and general election was called for the end of May, the legislation managed to, after a long process, make it through Parliament and receive the assent of the President. So the main goals, as I mentioned, was to implement the requirements not only of Article 12, but also General Comment Number 1. So basically, the explanations, we'll also hear more from the UN Committee. See that there's Professor Schaefer with us. But basically, the explanations as regards Article 12, which are set out in General Comment Number 1. So basically an overview produced by the UN Committee on the rights of persons with disabilities, on supported decision making, and how this right should be implemented in practice. So what the law does, the Personal Autonomy Act does, it's not a freestanding act. It amends a number of different laws. The main laws which it amends are the Civil Code, from which the institutes of guardianship, curatorship, or now also personal autonomy safeguards will emerge, and also the Code of Organization and Civil Procedure, which is basically the rule book for civil procedure in the Maltese system. It also aligns the Mental Health Act to make sure that persons subject to that act have access to supported decision making. There's also, did not mention it here, an amendment to the Marriage Act, because there were still limitations on a person's right to marry if they were adjudged to be infirm of mind. So that is also amended through this process. So supported decision making is the main aim. So basically the law now affirms, through the way it is amended, everyone's juridical equality, and that every person is the holder of legal capacity. However, a person can request that they receive support, a support person for decision making, and also in certain areas that there would be co-decision making. This can also happen through a support agreement, as happens in a number of other jurisdictions, such as in certain Canadian provinces. So the law allows for this, and also focuses on the choice of the person. You still have a structure in place, as you have, for example, the decision support service in Ireland. Because at the end of the day, these persons will also be involved in certain major legal decisions in the person's life. So it's important to have state oversight. But at the end of the day, unless we see that there's undue influence on a person, for example, something like that, the law directs that it is a person of the person's choosing that is appointed. So instead of reinventing the wheel, we had the current guardianship board. So instead, it's going to be reformed into a personal autonomy safeguards board, but it has to apply the principles of Article 12 in General Comment number 1, so the will and preferences of a person being paramount, and also rather than having simply a doctor, a judge, a retired judge, and a parent representative, there will also be representatives who have a bit of a holistic outlook, for example, representative of the Victim Support Agency or allied health professionals. So you always have between 5 and 6 people, and these are the structure that will actually be handling the process. There's also, because obviously things change with time, an obligation that legislation is reviewed regularly, by the Parliament Social Affairs Committee, so that we can actually see how something is functioning, how legislation is functioning, and be able to make necessary changes as time goes by. This is also something which you have, for example, in certain EU laws. So the order that appoints a support person, formally appoints a support person, or that also institutes co-decision making, shall be called the PASO, Personal Autonomy Safeguard Order. And as I mentioned, it can be supplemented by support agreement. And also you need, as was mentioned earlier, I think by Marine, resources for this. So a deputy registrar, a set from registrar for the board, is written into law. There's also a requirement to ensure sufficient administrative and social work services, for example. So we can uphold that holistic perspective. Very importantly, as also required by General Comment number 1, the best interest system, the old system is being put aside in favor of a system which upholds the rights, will and preferences of a person, the system the UN Convention. However, as also General Comment number 1 mentions, there can be situations which are the exception and not the rule, in which a person, after pertinent and real efforts would have been made, the law mentions this, to ascertain a person's will and preferences, the right to be heard, basically. When this is not practicable, then the support person would be obliged to make a best interpretation of the person's will and preferences. Let's say a person is in a coma, for example. But in that case, there's a number of rules also listed in the law. So you have to, for example, look at a person's past lifestyle, see close associates of the person, what they can say about the person, and also document this. So this is important. So let's say you have somebody who's actually involved in a matter of a person, writing their will, for example, or making certain dispositions. Then in that case, you obviously need to make sure that you have the process documented. It is important that a support person is, as we said, the key emphasis is on the choice of the person being supported. However, if a person cannot find something to be a support person, there would be a state pool, for example, of social workers and other persons who are recruited publicly through transparent expression of interest, and remuneration can also be provided for the service of these persons by the state when the money cannot be drawn from the person's estate, to make sure nobody is left without support or nobody is institutionalized just because they do not have relevant support. And then there's also anti-abuse safeguards. For example, possibility of civil redress if you had wrongdoing by a support person, and also if the support person is involved in administration of property, then there's hypothecation of part of that person's property, which could be requested by the board. It was already an obligation for Malta in 2021 when we passed the UNCRPD Act. It was always an obligation to UN level, since we never had a reservation on Article 12. It was mentioned in our state review in 2018 by the UNCRPD Committee. It's also mentioned in the National Disability Strategy and the EU Disability Strategy, also as a step towards independent living, Article 19, and we tried to look at best practice examples from other countries and spoke to a number of different experts. So, like that is the legislation on supported decision making. Obviously, there will be challenges, which I will come to, but I wanted to make like a couple of small points. Also, the whole support versus protection, like discussion that comes up from time to time. So with support, there's a number of support measures. So there's support persons, yes, that's like the main structure, but there's a number of different elements which can support a person in exercising their legal capacity. One of them is the provision of personal assistants. So a personal assistant would be a person who's not like directly involved in decision making, but like can also assist a person in activities of daily life, be it self-care, be it, let's say, other, let's say, more complex like procedures. It is a user-directed service. I know it's one of the things also which Enel like push a lot. So we had also proposed specific legislation. Now Parliament is dissolved, so the process has to be restarted after the elections, but to write the right to personal assistance into law, and to have a specific board written into law that would like manage state funding for persons who actually like choose their own personal assistant and would need government funds to be able to pay like such persons. So this is a support measure. So with support measures also, there are like these measures which are offered in Malta and which we also wanted to legislate about. So we have the structures for support decision making and also personal assistance, where these schemes already exist in Malta, but we wanted to write them into law to give them legal protection. But then there's also the issue of protection. So look to protection measures. These are covered to another act which was like adopted, the PASVA Act, Protection of Adults in Situations of Vulnerability. And with this, I'll just go very briefly. So the difference is this. So a person may still be at risk of abuse, harm, or neglect. So this is about ensuring that there's a structure that persons can actually go to in case they actually feel that their rights and freedoms, be they fundamental or otherwise, for example, their property rights, if they are actually being not respected, then like there can be both civil redress and or criminal redress, but also that there can be like a structure. For example, have like an individualized support plan or specific assistance. For example, have a social worker or monitoring. So like with this act, then it deals specifically with protection of a person's rights. It like does not impinge on a person's like legal capacity, but it actually like allows for a framework for persons who find themselves in a vulnerable situation because they're disabled, because they're older persons, but because, for example, like they had a loss in the family, they're grieving, like they lost their job, whatever. So if they find themselves in this situation, there's a whole structure now whereby like the locators for this. There's a number of different competent authorities that deal with this. For example, the Victim Support Agency, the local mental health services like agency, Active Aging and Community Care, Agencia Support, which is the state disability service provider. But in basically, if anyone reports to the director or to the police, and who then reports to the director that there's a concern, then like there's a joint committee that will decide what kind of assistance or what kind of individualized support plan was part of the assistance. Can also be, for example, a recommendation to have supported decision-making order. And then, like this way, the necessary protection that can actually like be given, necessary assistance, so individual things, or else having a plan which is multi-agency, and like if necessary, then a person or anyone else around the person, or even the director can go to the court asking for a protective or emergency intervention. Like this is, for example, if a person is at great risk and like needs to have somebody removed from the residence, like let's say in cases of domestic violence, then in that case, like you would actually be able to ask for a court order. So this is like the protection element. There's like the usual stuff about the data protection, but also a system of clearance certificates and an offenders register. So anyone who volunteers or works with adult situations of vulnerability, like will need to have a clearance certificate for this. This is also the case in other countries. There'll be intelligence sharing for this. So this is like the protection element. Now, we had extensive pre-consultations, public consultations, been ongoing since 2018. There was parliamentary approval. But still, the mindset will need to be changed. So there'll be a circular to existing guardians, engagement with government offices, banks, training. So this will be difficult. However, I wanted to mention one thing, like since it was also mentioned by Enel, This legislation is also linked to the Hague Convention on the International Protection of Adults. So basically, like a convention which allows for the circulation of certain measures, protection measures or support measures around Europe, like without the need for additional formalities. Malta ratified like this legislation like in 2023, but it also added a buffer. Like, so with this legislation, like the recognition of certain, let's say, measures in Malta can be challenged, and there's a procedure for challenging it. So the measures are automatically applicable after registration with the Court of Appeal, but still it can be challenged, for example, by the director or by any person with legitimate interest. And this is important that we have this added like safeguard there. And I know there were actual concerns also, which was also an opportunity to be addressed. This was always Malta's position in the regulation being negotiated at EU level, the regulation on the protection of adults, which seeks to have a European framework together with having a council decision, which obliges different EU member states to ratify the convention. So the convention is like a knife; it can be used for good reasons or for bad reasons. Having easier circulation of measures is good. It all depends on which measures circulate and what safeguards there are. And there are the safeguards in the regulation so far. For example, with grounds for refusal. Okay, on which grounds should EU member states agree to refuse recognition of certain elements? There are certain issues which are still open. I'm speaking about obviously documents which are still public. Negotiations are still ongoing, both within the Council of the EU and within the European Parliament. I will let relevant officials speak about that. But still, this is an opportunity which should not be missed.
If you can just wrap up, please.
Yes, I will wrap up. So the last thing is with EU actions, and ask about that. The European Commission's Disability Platform may be a good way to actually coordinate among different member states, because at the end of the day, it is national laws that actually have to change. We can't dictate to other nations. They are all sovereign, even if we have all ratified the International Convention. So it would be good for the EU to coordinate some action, but have to remember, and in the end, that everybody is sovereign. So that's it. I was also going to mention that we have monitoring by the Equality Body in Malta of relevant measures, and also the State Disability Service Provider. Practitioners have been asking for this for quite a while, but there's monitoring written into the law also by the independent watchdog Equality Body. That's it from my side. Thank you.
Okay. Thank you very much, Alisa. And thank you to all the panelists of this panel. So we heard a lot. A lot is coming. I think many of you have many questions. We will have enough time. At the end, we have more than half an hour foreseen. But I think we deserve an hour break. And so we can come back on 3:05 to continue with the next panels. And at the end, we will have a question and answer session where we could ask a question to all the panelists except those who send it a video. But we can definitely have separately after this conference. Thank you. Enjoy your break.
So I'm thinking it's on. They can't hear me? No?
Now we do.
Yeah,
now we do.
I can. Yeah? Now, okay, very well. Thank you.
Also, the presentation, make it bigger, please. Okay.
So if you don't mind moving to the next slide, Veronica. So I first want to talk a little bit about the Hague Conference and the type of the organization that they are. And this is the Hague Conference on Private International Law. As the name suggests, they're based in The Hague, the Netherlands, and they're actually older than the United Nations. The first session was held in 1893. And then this Hague Conference became a permanent international organization in 1955. And now it has 72 members. The members of the Hague Conference are all states. So it works primarily with states. And the Hague Conference works in the field of private international law, so it doesn't work on substantive law, what we mean, when we talk about independent living or a particular right of persons with disabilities or a right of children. They don't work on that, but their aim is to unify private international law. So whenever individuals cross borders, whenever judgments cross borders, the aim of the Hague Conference is to adopt conventions and ensure that rules are recognized in different countries. So their aim is that if a person crosses from, say, the Netherlands to Belgium or the Netherlands to France, the rules, countries know which rules to apply in respect of that person. They also want to know that it's not only which rules, but which law applies, the law of France, or is it the law of the Netherlands, or some other law. And this is primarily how the Hague Conference works, and what they do. So they adopt conventions, usually in this kind of field. And once a convention is adopted, we have the Adult Convention, which was adopted in 2000. The Hague Conference organizes special commissions on the practical operation of these conventions. So it looks how the convention works. It sends questionnaires to states to assess what is happening in that state in relation to the convention. It works sometimes with judges and professionals in those countries. And usually these conventions have central authority, so administrative bodies in each country which ensure the operation of the convention. It is very important to know that the Hague Conference works primarily at state level, so it's very little engagement with individuals outside state level and outside organizations. So I think concerns of private individuals are hardly seen there. And also, because of the nature of these conventions that they work, it is important to note that they work primarily on the principle of comity and mutual trust. So the interest of Hague Conference is that their conventions and their rules are recognized by states. So if you think of the adult conventions, it is important for the Hague Conference and for the credibility of the organization and of the convention itself, that the rules that are set there are respected by states. They are not really enforcement mechanisms, so it's not something like the CRPD committee where sometimes you can complain and you can reach the committee, but it's based on cooperation. And again, the cooperation, it's at state level. So this convention work because of the cooperation between states. And this, I think, is important, and I will come back to it at the end, because this focus on cooperation and mutual trust, in my view, sometimes it is at odds with individual rights that also appear in these conventions. And now, moving to the Adult Protection Convention, I should say that this has a predecessor. So there was another convention adopted in 1905. So that's at the beginning of the century. You can find it, it's available online, and it was called the Deprivation of Civil Rights Convention. It's just available in French, but if you read it, the whole aim of that convention was to ensure how can we make sure that interdictions and deprivation of capacities are really heavily enforced between states. So the language, to the extent that we criticize the language of the 2000 convention, the language of this 1900 convention was much, much stricter and absolutely not taking into account individual rights of persons with disabilities or anybody who might have been considered vulnerable in that convention. Anyway, there's not enough time to talk about the 2000 convention, but as I said, you will hear that it really, and it is true, it doesn't talk about individual rights. That this convention, the aim is to have protection decisions, as they are named, recognized in different states. It also wants to make sure that the applicable law, which law is applicable, is clear between states. So if a person, for example, moves from Ireland to Belgium, and that person falls ill in Belgium, right? And we don't know, that person is in a hospital, who will be able to take decisions? On the basis of which law will we take decisions? Will it be the Irish law or will it be the Belgian law? These are the kind of issues that the convention is envisaging. And of course, it is really based on cooperation. It is also touching upon this issue of advanced directives, and that the speaker before me talked about, in a way that it can happen. There are situations where, say, for example, a person is living in Spain, he or she is of Bulgarian nationality, and that person has left a mandate, an advanced directive, but that person travels to Bulgaria, and they can, something may happen in Bulgaria. There's an agreement, say that person is under guardianship in Bulgaria. Which regime prevails? Is it the regime that that person has established voluntarily in Spain, or is it the regime in Bulgaria? These are the issues that the convention envisages. Now, it can't not touch on individual human rights. I will talk a little bit later about how and when individual human rights appear. I don't have much time, so I have to finish in 2 minutes. But before I move to that, I just want to say that these conventions can be changed. This Adult Protection Convention was adopted in 2000. There are not many states who have ratified it. There are just 16 countries. And the 1905 convention was never repealed, but states simply didn't use it. So because they didn't use it, there was a protocol later on, quite recently adopted by the Hague Conference, to say that this convention is not applicable anymore. So this convention can disappear simply through lack of use, and it has happened with previous conventions. There are sometimes protocols that are signed, but it's quite rare to have a protocol. I have seen very rarely amendments to conventions, just one protocol usually. But there is a possibility this convention is signed by 16 states. That's important to know, because if there would be a protocol, say the Hague Conference will adopt a protocol and will say in that protocol that we want to interpret this convention in light of the principles of autonomy of the CRPD, any new state that will accede will have to accept that protocol. So this is a possibility to ensure more visibility of the CRPD through a protocol, also specifically here in an instrument that has not been so widely ratified. If you don't mind moving to the next slide. Here I will talk very little about the hierarchy simply because of time. I just want to say that in principle, there's no hierarchy of norms. So the CRPD is not necessarily higher than the Hague Conference, but the Hague Convention, but the Hague Convention is not higher than the CRPD either. We have various rules of international law, and in principle, we want to ensure that there is a harmonious interpretation to international treaties. There are several rules. There's no need to go into that. But it is important to know that sometimes lack of harmonization of substantive rules, and that means, by that I mean, if countries don't have the same understanding of the CRPD, what has happened in the past is that the lowest acceptable standard will be the one that goes through. So this is the risk, a risk in this convention, and the risk that I have seen in the past on the basis of what has happened with the children's convention. And if you don't mind moving to the next standard. And I just want to give you 2 examples about how this has worked and why it is important to note. In the private international law instrument, so in the Hague Adults Convention, we can say that, and the Hague Conference is saying that the CRPD is the underlying norm, and that these norms are complementary. But at the same time, we shouldn't forget that the aim of the Hague Conference is mutual trust and cooperation. And the exceptions, human rights and individual human rights, appear as exceptions to this convention. So we have these exceptions to the recognition of judgment. So you have situations where, for example, because a state has not respected the rights of a person with a disability, or because a guardianship regime is in place, a country which has supported decision-making in place could say, we don't want to accept that other decision. So we don't want to recognize in our country, in Spain, a decision made in Bulgaria, because in Bulgaria they recognize guardianship and we don't recognize guardianship, and this is public policy. This can happen, and of course, it is allowed by the convention. However, at the policy level, the aim of the Hague Conference is to ensure that this type of non-recognition cases are kept to a minimum. So when it comes to advocacy, and what I have seen in the Children's Convention is that it has always, the level of protection has been decreased usually. And I will give you one example. This convention provides, in the children's context, there is an opportunity to be heard for children. There is such an opportunity to be heard for persons with disabilities, not necessarily with disabilities, for persons who are perceived as vulnerable in the context of this convention. And this opportunity to be heard has been interpreted as applicable not to a particular case, but only it is enough to say that it complies with human rights if the opportunity to be heard is given by law and not in practice. So if we have a law that says we give the opportunity to be heard to a person in a context, but that person was not actually heard, that's not a ground for non-recognition of judgment. So we can't really raise it in a cross-border context because the law allows it. It was just the individual judge decision which didn't follow that law. So we can say that the whole principle, because of the principle of mutual trust and comity, which is so important, it is more important to recognize the judgment than to uphold individual human rights. So because of this duality between the aim of cross-border circulation of judgments and human rights and individual human rights, which usually appear as exceptions to this cross-border circulation and fast circulation, there is a risk that harmonization will be done for the lowest standard. Again, this is a risk. There's no guarantee that it will happen like this. In my view, what will happen will really depend on the strongest states, because the strongest states have the power to drive practice also through other states. And there have been positive examples as well. In the Children's Convention, there were positive examples where children were heard more broadly, simply because in Germany, children could be heard from the age of 4, and this didn't happen in other countries, but Germany would consistently refuse recognizing decisions of children who were not heard and were of 6 years old. And for this reason, many countries now, in Europe at least, would have set a lower age for hearing children than they originally had. But again, what will happen, it will really depend on how states interpret this convention. Thank you very much. I have more to say, but I think my time is up already for a while. Thank you.
Thank you very much. So our next speaker will go and explain a little bit how this convention affects notarial practices and how it works.
Ma mislila sam, ne moram da nosim, neka mi stoji pa...
Can you mute him? Okay. So our next speaker is Maria Reyes Sanchez Moreno, and she's from the Council of the Notarios of the European Union, CNUA, and the Spanish organization. The floor is yours, please.
Thank you so much for having invited me today. I'm going to use 15 minutes of your time because my presentation is twofold. On the one hand, I represent the CNUE, the Council of Notaries of the European Union. On the other, the Spanish Foundation Equitas, a very special foundation belonging exclusively to the Spanish notarial profession, whose purpose is to support persons with disabilities. Clear evidence of the importance that the Spanish notariat attaches to this matter. It could even be said that I am also speaking as a practicing notary, specialized in private international law and comparative law, working in Alicante, where international matters involving persons with disabilities or potential future disability situations are very frequent. As a representative of the European Notariat, I must begin by noting that there are various systems addressing disability in Europe. We respond to three basic models: the traditional, the modified traditional, and the progressive model. The first revolves around legal incapacitation. However, the New York Convention on the Rights of Persons with Disabilities should, in my view, entail the disappearance of incapacitation. A second group of legal systems falls under the so-called modified traditional model, characterized by the range of protective measures allowing for a more flexible response depending on the needs of the adult in accordance with the principles of proportionality and necessity. France and the Netherlands, for example, follow this system. Finally, the progressive or social model is prevailing due to its simplicity. It includes systems such as those of Germany, Austria, Italy, Belgium, and Portugal. Protective instruments are reduced to a single sufficiently flexible mechanism, which may be administrative or judicial, and whose adoption does not necessarily require a prior declaration of incapacitation. This model best reflects the principles of the New York Convention. Since Europe contains diverse systems for addressing disability, the role assigned to the notary also varies, of course, although some general considerations can be made. European notaries have an international instrument, the New York Convention, which has become the new international and European public policy in this field and shapes their actions. This convention aims to promote, the autonomy of the will of persons with disabilities, but the true will must be supported and informed to produce full legal effects. The notary plays an essential role precisely by accompanying, listening, interpreting, and adapting that will, and there are many legal transactions that persons with disabilities can carry out before a notary throughout their lives. Different countries tend to resolve international situations in different ways internally. The CNUE has not adopted any official position on whether or not to ratify the Hague Convention on the Protection of Vulnerable Adults, considering that this issue relates to each member state's internal policy. Currently, in countries that have not adopted the Hague Convention, issues of jurisdiction, recognition, applicable law must be resolved using the internal solutions, which are often
A little bit slower, please.
Thank you.
Sorry for the caption.
Which are often fragmented or inexistent. The establishment of voluntary support measures, jurisdiction is not a problem for the notary, who usually operates under the principle of free competition. It is true that notaries are confronted with judicial decisions concerning persons with disabilities and must assess the international jurisdiction of the foreign authority that issued them. However, the main problems faced by notaries relate to the applicable law, like Simona was saying. Regarding voluntary measures, the question arises whether, before disability occurs, the internal rules governing voluntary representation always apply, and once disability occurs, the rules governing support measures apply. That can be the rules of the Hague Convention in the countries that have adopted it, or whether the latter should apply from the beginning. Many countries have already adopted the criterion of residence to determine the applicable law. While more flexible, this creates an additional evidentiary problem for the notary. This issue that does not arise where a professio juris is made, as provided for in the Hague Convention, though it may not be recognized in domestic laws of countries that have not adopted it. Another major issue for notaries concerns judicial authorizations or approvals required by law for the grantees when there is a change of residence. Should those of the new residents apply, or should the measure adopted in another country prevail, including the need of authorization or approval? Does the same apply to the requirement of confirmation as required in France? That's a question that I can answer. Regarding judicial measures, two basic issues arise. First, what should be done with judicial decisions of incapacitation from one country when the destination country does not recognize them? Here, the criterion of adaptation may be used. Second, what is the regime of authorizations and provisions imposed on the representative or assistant? It's the same. Should those of the new residents apply, or should those of the original measure prevail? A future EU regulation that will include the solutions of the Hague Convention will provide a harmonized set of conflict of law rules for all member states, adaptively improving the situation of persons with disabilities. The person with disabilities can have interest in other countries, and this facilitates the principle of free movement and establishment. The lasting power of attorney that this regulation will develop may be an essential instrument, as nothing is better than the person's own will to foresee and self-regulate a possible situation of disability, also at an international level. The notary's proximity to the individual, professional training, and ability to protect the vulnerables can make the notary a central figure in drafting such instruments. In line with other regulations, Recital 18 of this future regulation states that it shall apply to protective measures adopted by judicial or other authorities exercising judicial functions, as well as to authentic instruments and agreements between parties insofar as they have legal effects in the protection of adults. This includes a notarial activity within the framework of voluntary jurisdiction when applicable. For example, when a notary issues an authorization to the person in charge of the adult with disability, like in Italy, it's not the judge, but the notary who can do that. But the main function of the notary is as creator of public instruments intended to circulate freely within the European Union. The certificate of capacity envisaged by the regulation, if entrusted to notaries, as with the European Certificate of Succession in many countries, will be a key instrument to facilitate the safe and efficient movement of persons with disability. As a representative of the CNUE, so speaking in general. Now, as a representative of Equitas and Spanish notary, I will outline the situation in Spain and why Spain. Although Spanish law has not fully embraced the progressive system, it has become the most advanced in Europe regarding voluntary support measures, which take precedence over judicial ones and exclude them, favoring the participation of persons with disabilities in decision-making and placing the notary at the center of the system as institutional support. The approval of Law 8/2021 has brought a structural transformation of the Spanish legal system in matters of disability. This change entails a clear dejudicialization of support measures, which are now primarily configured as voluntary mechanisms designed by the individual. As a consequence, a process of notarialization of the system takes place, insofar as the notary becomes the main legal operator in the creation, configuration, and implementation of these measures. The role of the notary is twofold. The design of support measures is the designer of the support measures together with the person who want to establish them, and the intervention of the notary in the daily legal life of the person with a disability. Speaking about the notary as the creator of the voluntary measure, the system is built on the primacy of the individual's will. Whenever a person has sufficient capacity for understanding, it is they who decide what support they need, who should provide it, and how it should operate. The notary's role is to safeguard that will, ensuring that it is properly informed, freely formed, and free from undue influence. The more developed voluntary support arrangements are, the less need there is for judicial intervention, which is therefore reduced to a subsidiary role, give authorizations or to react in abuse situations. In Spain, we have 3 different voluntary measures. The first one is global public deed establishing support arrangements. This is a flexible and wide-ranging instrument, which may include personal and financial instructions, the designation of the person who will provide support, self-imposed limitations, and safeguards and accountability mechanisms for the support provider. This instrument was not part of the original bill, it was introduced during parliamentary debate, and it is deliberately open-ended with flexible boundaries and can incorporate other legal tools, such as lasting power of attorney, when it is needed to act vis-à-vis third parties, of a self-guardianship. Rather than replacing other mechanisms, the deed, this global deed, may bring them together or complement them. It may also include care agreements or maintenance agreements. Its content can be highly individualized. However, its effectiveness will depend on how clearly the instructions are drafted, whether there are workable mechanisms for implementation, and how the action of the support provider is supervised. This is a relatively underdeveloped figure with somewhat blurred contours and a strong dependence on notarial practice, because it can only be executed before a notary. Its success will actually depend on how actively notary is promoted and how carefully they structure it in practice. The second instrument is the power of attorney, lasting power of attorney. This is the star of the system, and we use that sparsely in Spain. It's very strange that in 1 week, I do not make one of these powers of attorney. It's, like I said, the central support tool. It allows individuals to plan ahead by designating who will act on their behalf if support becomes necessary in the future. In fact, there are two types of powers of attorney. Powers that remain effective even after the onset of disability, and powers of attorney that only come into effect once the disability arises. The first one is the most popular. The second one, for the second one, a key issue is when the power of attorney becomes operative, when the disability arises. At this effect, we must listen to the person with disabilities about which are the key moments where the disability occurs. So they decide in advance when the power of attorney is effective. It's not the judge who decides, like in France, the moment where the disability arises. It's the person himself. The power of attorney may be general or specific, financial or personal. In all cases, it should be tailored to the individual's specific needs. Both lasting powers of attorney and support needs must be notified to the civil register by the notary. This enhances legal certainty and provides a degree of limited publicity subject to privacy considerations. Although failure to register does not affect validity, registration is a duty of the notary. It ensures that if judicial proceedings are initiated, the judge is aware of any existing voluntary arrangements. Where such voluntary arrangements exist, judicial intervention should not take place. Even where they do not, if the judge finds that the person still has sufficient discernment to auto-regulate his situation, the matter should be referred by the judge to a notary rather than resolved judicially. We know the power of attorney as a unilateral act, but we also know a mandate. By contrast, is a contract that creates obligations. Mandate may be preferable where the aim is to strengthen the accountability of the support provider, particularly if remuneration is involved. It's not usual. It's the notary, in fact, speaking to the person with disability who decide if must be a power of attorney or a mandate. We also know the third instrument, the self-guardianship. In this instrument, the person decides who will be the guardian appointed by the judge if the disability arises. This instrument involves judicial intervention. So it's against the principle of the judicialization. Nonetheless, it plays an important role as a safety net. Everything fails, what I have resolved before, and can also be used to exclude certain individuals from ever being appointed. It is also usual that someone come to my notary office, I don't know exactly who want to be in the future my guardian, but I absolutely know that this person not. So that can be included in this instrument. As a general rule, the court is bound by the individual's wishes, unless there are serious reasons not to follow them or circumstances have significantly changed. That must be motivated by the judge. This reinforces the principle of autonomy. The last part of my intervention is what do the notary for the person with disability in the day-to-day life. The key requirement is that the person has sufficient understanding. The legal reform endorses this, but also requires the use by the notary of all available support tools to communicate with the other. Sign language, assistive technologies, trusted and trained persons to facilitate the communication. My notary office, for example, we use a big screen to develop the act so the person can read it easily. We must also do, as notary, is to adapt to this situation, including in our function, the use of pictograms or easy-to-read formats. Equitas has made an important effort to provide the notary with these tools that are not always easy to use in the practice. In some cases, assessing capacity is very easy, or is easy, using perhaps technologies, human requirements, but sometimes assessing capacity is not straightforward. So in Spanish legislation, we can use a notarial deed where the notary establishes where is this discernment. That's true. That is not explicitly regulated in the law, but it can be a valuable tool if used appropriately. That is, someone comes to the notary office and says to me, that is my will. For example, in one case, in my practice, someone came with physical limitations, some degree of dementia, who needed to sell his home to purchase a more suitable one. The record included the involvement of the family to resolve this situation, documented my personal meeting with him, and clearly established his true and rather complex wishes. It was a deeply rewarding professional and personal experience. You know, it's very difficult to develop a notarial deed of a purchase of a house if we have at the same moment say, that is what I have been speaking with the person. That is the reason I'm going to sell the property. That is my complex reason to do that. I want to be done in this way. So a specific notarial deed before can be very good for the privacy and to document the complex discernment of the person.
Still have 1 minute, please.
Okay. The role of the notary is different when someone comes with the power of attorney, using the power of attorney in the representation of the person. The notary must, of course, interpret the instrument to verify that it is still in force. It is also possible that the person has a curator appointed by the judge, so the notary must determine if it's assistive or representative, this curatorship. And finally, in Spain, we know de facto guardianship, that is a practical situation that the notary can also establish in the practice, and this situation also asserted by the notary can go to the civil. My conclusions, and I finish. With the new law 8/2021, the notary's role is no longer merely formal. It now involves providing tailored legal advice, supporting the formation of the individual, for the individual's will, and ensuring that their autonomy is respected. The success of this new model will depend largely on the notary's expertise and sensitivity and their ability to adapt to each individual case. It's not always easy. It's a challenge. Ultimately, the notary emerges as a key factor in making the new support system truly effective. One can even speak of a genuine notarialization of disability law in Spain. This, in turn, facilitates cross-border situations as notaries are able to create instruments that reflect the individual's wishes and can be used abroad, particularly within the European Union, where the free circulation of public documents is warranted. At the same time, cooperation between European notaries helps ensure the support arrangements created in one country are properly understood in another, without prejudice to the role that notaries may play in issuing certificates of capacity under a future EU regulation. I'm very optimistic about these certificates of capacity for the benefit of the persons with disabilities in the European Union. Thank you. thank you so much for your attention.
Thank you, Maria. So without further ado, we are going now to the United Nations Convention on the Right of Persons with Disabilities and the legal obligation under it. So we have the honor to have Marcus Scheffer with us. He's the rapporteur for the EU at the UN Committee on the Rights of Persons with Disabilities. Please, Marcus, the floor is yours.
Yes. Good afternoon, everybody. Hi, Nadia. We are already in overtime, even though I'm just beginning, so I will try to keep it short. How are we dealing with the slides? Are you showing them, or should I show them and then?
If possible for you, I think it would be the easiest.
If I do it, okay.
Yes.
So let me do it. I cannot share it. It tells me that only the host can. Now all participants. Okay. Let's try doing it, huh? Yes. Want to continue? Oh, all right. Well, that's one. Is it on? Or is it working?
Yes.
Somewhat.
I mean, we see it not in full screen, I think, but it's okay.
Is it working now?
Yeah, I think we are good. It's okay. We don't see it in full screen, but it's
I have it on full screen here. I have it on full screen on my computer. But if it's large enough, that's fine. Okay, so
try one more time. Yeah. Yeah. Let's see. Now it's perfect.
Okay, very good. So I'll be brief, as we are already in overtime. Now, the committee did the review in March of last year, 2025. And we also, of course, dealt with Article 12, the guarantee of legal recognition before the law. I would like to briefly walk through Article 12 and then get into the issues that we found with the European Union, in particular also the Hague Convention that Simona already walked us through. Now, Article 12, if we remember, we have first the recognition of the right to be a person before the law. Now, this was uncontroversial. Everybody has rights. The problem comes with the next part, to exercise those rights. Enjoy legal capacity, which means to be able to have rights, but also to exercise the rights yourself. This is the basis in the convention against substitute decision-making, the provision that requires states to introduce supported decision-making regimes in all aspects of life. So the convention makes clear that you cannot have any exceptions to this. We have the necessity and the requirement of states parties to provide, as the convention says, appropriate measures to provide access to the support they may require to exercise their rights. So you have to have a supported decision-making regime that provides the necessary supports for persons with disabilities to build their will and to express their will without bias, without undue influence. And in order to ensure that there is no undue influence, the convention refers to safeguards, a provision that I don't want to go into. It's just, it gives rise to many misunderstandings. And in the end, it also the convention focuses on areas that are of particular importance, because very often, even in states parties with supported decision-making regimes, these are problems. If we look at Spain, for example, bank loans, mortgages, and other forms of financial credit need to be included in the new decision-making regimes. Now, when we looked at the EU, we first saw that the EU isn't doing much to work towards removal of guardianship regimes in member states. Now, there is a specific problem with respect to the Convention or to the European Union. The European Union only has limited competencies, and this is never the case with states parties. So we could not simply tell the European Union to erect or to establish a supported decision-making regime, as it doesn't have the competences to do that. But we still first noted with concern that they're not doing anything to nudge their member states to remove substitute decision-making regimes. We also noted that the European Union decided to authorize its member states to ratify the Hague Convention. And as Simona noted, the Hague Convention contains a significant risk that substitute decision-making regimes will cross states' borders into states that have supported decision-making through the mutual recognition of protection decisions. That is a problem that we saw in our review, and that we then addressed. I'm coming to that shortly. We also saw that there are significant barriers for persons with disabilities in the EU to control their property, their financial affairs, to have access to bank loans, and so on. The things that we saw, the convention explicitly protects. Now, what did we do with these concerns? We issued the following recommendations. First, and this is quite weak, call on member states to replace substitute decision-making regimes with supported decision-making systems. Because the EU does not have the competence to issue legislation in this area, to force member states how to deal with their decision-making systems, we decided the EU still has many levers to nudge and to push member states to change their substitute decision-making regimes and move them to supported decision-making. We remained vague because the many measures that there are, we from Geneva could not fully comprehend. We also, and this is a central part, recommended to the EU to halt efforts to authorize member states to join or to remain parties to the Hague Convention. The Hague Convention, in our view, should not be used in the current form because it states that as a rule, a regime moves with the person into another country, and only as an exception it doesn't. Now, Simona, I admire your optimism when it comes you mentioned Germany's role with the right of children to be heard, and how basically the Germans pushed the other countries to accept the right to be heard much more broadly than they would otherwise have. I am not quite sure whether the same mechanism would take place under the Hague Convention with respect to substitute decision-making regimes. When we look at the European countries, that some of them have changed their from substitute to supported decision making. No country has fully changed. Even in Spain, you still have the possibility that the court can appoint representatives. In other countries that had quite promising legislation, like Austria, the situation is worse than before. Simply because of federalism, because the Länder are not willing to establish the necessary support mechanisms. And the federal government explains that it's not their competence to do that, so it's not working. In fact, we have more people under guardianship now in Austria than we had under the old law. So the development toward supported decision-making is slow, and it's not at the stage yet where we can trust that through the strength of some countries, others will follow. Finally, we also recommended to the EU, and here they do have legislative powers to eliminate discrimination of persons with disabilities in the area of property and financial affairs, banking services, the type of business dealings that the convention explicitly refers to as well. So this is a very brief walkthrough through this. We, of course, would have much more to talk about, but we don't have time. We are already 13 minutes over time. Thank you very much for listening to me.
Okay, thank you very much, Marcus. And so without further ado, we are going now to Georgia to see how access to legal capacity was working there. And so we have with us Dia Arivanchivil. He's from the Alliance of Women with Disability in Georgia. The floor is yours, and please try to get stuck to 10 minutes.
Hello, sorry, my office a little bit noisy because we have event in our office, and many of our friends try to celebrate with us Independent Living Day. Can I share my presentation? Yes.
Yes.
I think so. Okay. I try to make it with easy read for our friends to. Sorry. It's you can see my presentation.
Yes, we see some gray boxes in the middle. Probably you have some things opened over this presentation. But okay, yeah. Move.
Oh. Before 2014, we did not have this law like we have a guardian, but after the court case, when the many intellectual disability persons try to protect their right with election rights, court says this law are not fair and it must be changed. But the old system guardianship chair removed, and we have now supporter service. It's new system to create support, like people with intellectual and mental disability can make their own decision, and only court can decide which part of life he can take the decision making with supporter. We have fully supporting and partial. It means we have one guy in our office with autistic disability, and his parents have only supporting space for the like priority to buy the flats or something or sell, but his salary and everything for financial operation is its own decision. Also in personal assistance service, we have partly like supported also filling the questionnaires with tables and everything. Realistic in paper, we have good law, but in real life, it's with many problems because we have supported, but we have not services to help increase the living independence with mental and intellectual disabilities. Unfortunately, it's some people think like it's only changing name. It's guardian by supported, but mainly it's the same. Like parents make the supporter status and things they can make decide to everything with the child and daughters or sons. So in papers it works very well, but in real life it's if you have lucky and you have good like judge and he make a good decision and not make a full support by decision, it's okay. But unfortunately, problem is like sometimes other people still decide interested person, and courts don't allow courts don't allow individual cases. It's like copy paste decision, and so unfortunately courts don't see individual problems. And we have some cases with non-intellectual disabilities was physical disability persons, and when they family members asking the supporter service to make decision, court makes this decide to give them support status, but it's what is problems. Assistance focus much on medical problems. It's not so in social life. Even the personal assistant service did not recognize the intellectual and mental disability person's wishes. We have our cases. We are also providing personal assistant service, and every time parents and family members try to push us to make the schedule and everything. Like if we have a few days ago case like girl want to go outside in the rain, and his parent decide to don't let her go, and this assistant said I can do nothing because this family decides this. But it's not I'm a little bit losing sorry with my English. It's not work in real life. My main problem is institution, because people still in living institution. We have the institutionalization reform, but in mainly nothing will change because big institution change with smaller, and so sometimes see who are the worker in institution are also supporter. And when we have cases when the supporter makes some not protect so sorry maybe supporter an institution breaking law with mental disability persons, we cannot support them because the person who break law and who are supported is same person, so we cannot help them, and we cannot defend them in court because only support them only supporter can decide if his illegal system. Also, we have cases under maybe you already know in Georgia is for more than 500 days under protest against the Georgian Dream. So we have 3 cases in court when the physical disability persons blockade streets and they get fined. And in the court case, judge and prosecutor asking doctor like make decision if we can understand what we protest. We have not intellectual disability, but they think we don't understand what we do. So it was already 3 times, and the last case was a few days ago. with guy with he have a mobility disability only with one hand, and prosecutor wait doctor decision and psychologist decision if he can understand what he do like this. And the main topic in Georgia is now about legal capacity, about the child with Duchenne syndrome, because parents asking the drugs with experimental drugs to save their children's right, but government said it's risk and we can afford these drugs because it's only experimental and it's risky. But so if we see like this, if we have legal capacity and we can make our decision, so why parents cannot choose and adults with Duchenne syndrome cannot choose which kind of drugs they can take, experimental or not experimental, if we have the like life or die situation. But government think we cannot take our risks, and they think make decision for us.
If you can go a little bit faster, please, if you don't mind. Still have 2 minutes.
What? Sorry.
Still have 2 minutes, please.
Okay, sorry. We have also problems with old laws because remote all guardianship ideas completely not we need in our legislation. Stop conflicts interest in like supporter and working with institution cannot be same person. They also raise awareness about supporter service, because people don't understand what it means. It's like not substitution. It's only help make decision, but people in Georgia did not understand, know what's it mean. So also we need in institutions strong monitoring and independent and better court decision with this, because unfortunately only size changing in Georgia practically, and nothing changes. So and also we need to train judges with in social workers, police to good understanding with what that mean, because we have only laws very well, but in mainly when we go and try to take some services and with legal capacity we don't have nothing, because in especially in rural areas, policemen, judges, and nobody can understand our right. And when we have cases by GBV or something, they cannot trust, and they can don't listen the persons who have psychological disabilities, that because people's with psychological disability did not take the disability person status official to avoid the stigma for this, because they know they will lose their legal capacity in government eyes. What we want from European Union is making this issue very important from Georgia, and more pushing from EU. Look not only laws, but also they work with real life support training and awareness, support independent monitoring, and make sure rules follow the CRPD. We have also a CRPD decision about supporter system in Georgia, and the CRPD tells it's only in papers practically, and unfortunately in Georgia we still not have services in real life. And now in even the personal assistance, people don't understand what it mean, and sometimes people think it's like nanny and not PA, that will for us means PAs. Sorry, unfortunately, I was a little bit busy day and my English not so well, and I was worried because it's my first presentation, and it's our slogan for today. It's because main goal is Duchenne syndrome child save lives. We make like for today, so we are too much smart to be quieted because we want to be more noisy and state must listen us.
Okay, thank you very much. You have done it very well. You were clear and very to the point. Thanks a lot. So without further ado, we go now to the future, how to go further. So we will have perspective from different stakeholders. We have? Okay. Okay, yes, sorry. So we finished this panel. Thanks a lot for this panelist. And I invite the next panelists to prepare themselves, join us. We will have a little bit about, what are the successes, the legal capacity now, and we will try to see how we can make some progress and how we can address this on national, international level, and also what the EU can do to support the right of legal capacity, despite the reform of the 2000 Hague Convention. So welcome to the panelists now. So without further ado, I give the floor now to Christophe. Sorry if I mispronounced your name. He's a member of the European Parliament, and please, the floor is yours.
First of all, thank you so much for having me, and I'm very sorry because after this intervention I need to disappear and I need to get back to the European Parliament, but I'm absolutely and extremely honored to be a part of this event, and I'm especially moved because before joining the European Parliament and the Polish politics, I'm from Poland. I was one of the founders of the legal organization that brings together lawyers only that fight against discrimination. And for us, because we are going to talk about European Union law and legal incapacitation, we always treated legal incapacitation of people with disabilities or people with specific limitations as a form of unequal treatment or even discrimination. So this, my presence here is not only because of professional reasons, but also I fully support all the actions that you are having on your agenda. So, as I was introduced, my name is Krzysztof Smiszek, and I'm a member of the Socialists and Democrats political group in the European Parliament. But what is more important for you is that I'm a shadow rapporteur, also one of the persons that is dealing with the draft regulation on I'm sorry, it's afternoon, so I'm also having difficulties with expressing myself. But the regulation on supporting adults in transnational protection of adults in transnational situations. And maybe just one thing, before I joined the European Parliament, I was a Deputy Justice Minister of Poland. And the regulation that is being now discussed between European Parliament, the Council and the Commission was one of the priorities of the Polish government during the presidency of Poland last year. And I was supervising as a Deputy Justice Minister all the European Union issues, and that was my decision to focus our presidency on this regulation. So you can see that I'm a person who is more or less informed what are we talking about now during this panel. So and maybe one thing, because I perceive my role as a politician just to be a kind of a transmitting belt between the civil society and the institutions. And now when we are working on the final text of the regulation, I want to thank you so much for being extremely active in the legislative process, because many amendments that I proposed as a shadow rapporteur to the regulation were actually presented by the civil society. So that was my privilege, my honor to be, the guy who received your input and to present it to the European Parliament, to the report. So maybe in this short intervention, I would like to focus on one of the aspects of the regulation that is supported decision making. As you all know, in the European Parliament, we were very vocal about that. We are of the opinion that legal incapacitation is a kind of very old-fashioned thing that should disappear from the European, let's say, legal landscape. So that is why we were extremely vocal in terms of introducing the measures of supported decision making. And actually, I see the roots of supported decision making in a basic human rights value, which is dignity. And I'm a very big fan of Article 12 of the convention, UN Convention, and I let's say treat this provision of Article 12 as a source of interpretation that all the supported decision-making tools are much more, I would say, effective than this old-fashioned tool, which is legal incapacitation. And that's why I'm brave enough to say that in my mind, legal incapacitation constitutes a form of discrimination based on sometimes on disability, sometimes on other let's say limitations that are constitute kind of obstacle for certain persons in full participation in the social life. So now we are at the stage in terms of the regulation. So we are in the stage of so-called trialogues. So we held a first trialogue between the Parliament and the Commission and the Council. That was a very technical one. And next week, as far as I remember, we are going to have a, I would say, proper meeting between those three very important institutions. And I'm pretty sure that we are going to have a fruitful discussion, fruitful debates, and the European Parliament report is kind of strong one. So we are going to defend our position. Maybe one thing that might be of interest for you. So we propose to add a new definition in the regulation, which is a definition of protection. And maybe I just read it out since maybe it is not so popular so far. So we would like to have a legal definition of protection, which goes as follows. Protection should be understood as support, representation, or other means that enable an adult to exercise their legal capacity through supported decision-making, co-decision-making, or representation, or to protect the person or the property of the adult. So we are of the opinion that it, let's say, is broad enough to cover many situations, many life situations by this definition. And let's see what the trialogues will bring. But I just wanted to say that the European Parliament is very much attached to the concept of independent living, which is provided by the UN Convention on the Rights of Persons with Disability. We treat this convention as a kind of lighthouse for us, well, we've got plenty of arguments that the UN Convention concepts should be the leading ones. Also, we need to bear in mind that the Luxembourg Tribunal used UN concepts many times when deciding discrimination cases based on disability. And I think that there's no way back. We just need to follow what the Luxembourg says and what the UN Convention says about supported decision making. And I'm very happy to see that many countries, many member states are following this concept, including my country, Poland. The government, just to let you know, that the government of Poland is finishing its works on the specific law on supported decision making instruments that will be, to the very, I would say, high extent, replacing the institution of legal incapacitation, very old one from 60s, I would say. And the Polish government is very much determined to take on board all the, let's say, progressive concepts on board. So by that, I would like to finish. But once again, thank you so much for having us lawmakers here in this room. This is extremely important for us to be in a constant dialogue with the civil society. You are the source of knowledge for us. We are, politicians who are extremely busy with absolutely different topics. One day we are dealing with independent living. Next day we are living with completely different topics. And this is also my experience as a former human rights defender. Actually, I'm perceiving myself as a human rights defender in the European Parliament. That the knowledge and the wisdom of the civil society is of utmost importance, and you are the ones providing us the current state of play and the needs that needs to be addressed in the European Parliament. So thank you so much for having me, and I'm very looking forward to the further exchange. Thank you so much.
Thank you very much. We'll definitely follow up with this and bring it out.
Yeah, and I'm very sorry, but I need to escape. But I'm keeping fingers crossed for your works, and I encourage you to keep fingers crossed for our work next week and weeks that will come. Yeah,
thanks.
Thank you so much. Thank you.
Thank you. Now I will go further to the next speakers of the panel. I will challenge you a little bit if you can reduce your timing to 8 minutes so that we still have some space for debate afterwards, please. So the next speaker on my list is Freddy Hussein from Inclusion Europe. The floor is yours, please.
Do you hear me well? So that's okay. Yeah. So thank you very much, Enil, for inviting Inclusion Europe to speak at this panel. Supported decision-making, the right to decide, is an important issue for many people with intellectual disabilities and their families living in Europe. And do you know what year is it this year? You remember? Big year for us, no? No, not in this room. Yeah, maybe. Yeah, but you read my speech before. This was why. Yes, so this is the 20th anniversary of the UN CRPD, and still today in Europe, a judge can sign the paper and can say you no longer exist legally. Maybe we should ask ourselves the question, did we fail somewhere? Like, I'm really sad that Mr. Simsek the room, but I really want to show another story that show how the removal of legal capacity looks like in Europe. So this is the story of Andrea, Romanian self-advocate. And turning 20 years old was a big year for her. This is the year where a judge will decide if she keeps her legal capacity or if he or she will remove it. And the big day arrived. You have to picture it like a room, judge in front of you, staring at you, mother on the side, being stressed. And now comes the question that will determine if she has the capability to decide or not. What is the color of this cup of tea? And I'm not lying. This is the kind of question that ask judges in Europe to determine the legal if people have the right to decide. 20 years of hearing this kind of stories, people traumatizing by legal procedures, 20 years of hearing the same arguments everywhere. It's too dangerous. They will empty their bank account. They will get married to the wrong person who will abuse them. 20 years of fighting an old system, guardianship, built on fear, and then they say that it means to protect people. And now, where are we now? Marine from EDF shared some numbers at the beginning, and it's really roaring. At Inclusion Europe, we run a survey every year. We ask our members, what is the state of the right to decide and supported decision-making in your country? And we found out that in 15 countries, legal capacity can be partially removed. This is the case, for example, in Belgium, the country we are in now. In 14 countries, it can be fully removed. And I'm really sorry that Mr. Simpson from Poland left, because Poland is one of these countries as well. And do you know how many countries we found that the laws say the right to decide is respected and supported decision-making is provided? 4 out of 53 in Europe. So why? Why, really? And we asked ourselves this question many times among disability advocates, and we hear things like government just need more time. Yes, but 20 years, they have brilliant members of the UN CRPD committee all the time explaining general comment number 1 and also conclusive observations that they give to countries. We heard also, maybe it's a lack of political will, but today as well, we heard government from Malta, from Poland, and others. For example, tomorrow we are going to Cyprus for the EU presidency. They are running a reform there where they are going to hire 80 decision-making advisors. So the political will is there, and we can create it. We heard also people don't understand supported decision-making. And so thank you today, because we really had an answer, good examples on how it works, but maybe we can do better. And this is what we asked our members last year. What can we do better to make sure that supported decision-making is a reality in Europe? And the thing is that they did not come back to us with a list of government failures or recommendations, etc., but they came back to us with a list of something that we can do better ourselves, disability advocates working with decision makers as well. So the first thing is the narrative. We have been saying supported decision making as if everyone understands it. They don't. What is supported decision making? Everyone needs to remind that every one of us here in this room, in the world, we make decisions with the advice of others, with information, etc. So when it comes to big decisions and people with disabilities, it's a reason to deny their right to legal capacity. Like supported decision-making is not a disability thing, it's a human thing, and it's important that we make sure that everyone around us understands it. The second thing that maybe we can do better is to show examples of supported decision-making. So thank you, Enil, today for inviting Nicolas, Simon, to show how supported decision-making work in reality. These are examples, real examples, not just dreams. And decision makers have they have to see it to make laws working better. And the third thing maybe that we can do better is to work with you, the European Commission, and with countries, like to design a roadmap together. And we have to say what needs to be exactly in the roadmap. So first, the law, we have talked about it, a law that removes substitute decision-making, that recognizes legal capacity for all, and that makes sure that people have the right to support everywhere. The second thing is the policy. We need funding, we need training for judges, for notaries, etc. And governments, they have to make it possible. Yes, this is not, for example, the competence of the European Union to write a law about that, but you can use funding, you can create tools, so member states know the way on how to reform their laws. And the third thing, maybe that we can do better, and we have to work together, is to build a society where people are trusted to make decisions. Like we need to work together so people live in the community. We live to work together so people go to inclusive schools, because in this kind of environment, they will get the skills. They will be empowered to make decisions in their life. So I just would like to conclude now. It's important that we work now together. At Inclusion Europe, we wrote a report on showing examples. You and Neil, you organized this independent living day, showing examples as well. And now we have to get in touch with policymakers. So I'm happy to share with you the report that we wrote. Please share also your narrative, your examples, your roadmap to your governments. Book a meeting and let's make supported decision-making work for everybody in Europe. Yeah. Thank you.
Thank you very much. So we have with us online Christian Garden from Mental Health Europe. Will give his input as short as you can, Christian. The floor is yours, please.
Thank you, Nadia. I suggest that I share my screen and my presentation, so because it will be easiest for me then to control it. And in this way, can you see it? In this way, I can skip and make things shorter.
We see it. Not in the full screen, but we see it.
Okay. So thank you very much for the invitation for this to this important conference. I will try to be as quick as possible and as short as possible, and not to repeat too much what my colleagues already said. But before I start, I first want to introduce you with the term of what are psychosocial disabilities, because this is often an issue that me or my colleagues are being asked what psychosocial disabilities mean. So there is no uniform definition of psychosocial disabilities, and the term first arrived from the community of persons with mental health problems when they participated in negotiations for drafting the UN CRPD many years ago. But since then, since the convention has been adopted and the CRPD committee started working, the committee in their concluding observations and their communications with the governments, they used consistently the term of psychosocial disabilities. Those are that arise from the interaction between individuals who experience mental health problems or psychological distress and the legal, social, attitudinal, institutional, and environmental barriers that hinder their full and effective participation in society on an equal basis with others. So it follows the definition of disability as in CRPD. Here you can see examples of mental health problems that are often associated with psychosocial disabilities, like, for example, depression, bipolar disorder, schizophrenia, etc. Experiencing one of those problems does not automatically mean a person has a psychosocial disability. Still, a person's situation must fall under the definition of the CRPD, definition of disability in the CRPD. Now, what is very important to note that we, as Mental Health Europe, we do not use medically charged words. So I will always try to avoid using words like disorders or conditions. What is important to emphasize is that, unfortunately, assessments of disability when it comes to persons with psychosocial disabilities are, however, still predominantly medical and rarely addressing social determinants of disabilities. And that is important to note when we talk about supported decision making, because if supported decision making is a service that is provided by the state, sometimes it will be necessary to establish that a person is a person with disability. Medical determination of disability usually relies on psychiatric medical reports, and it could happen that, for example, a person with schizophrenia would be deemed as a person with disability based on a psychiatric report, but the person with depression would not. It could happen that the person with depression would need more support in decision making than a person with schizophrenia, but because of lack of recognition of the status of disability that is so predominantly medicalized, we have a problem that a person with depression wouldn't be able to access services needed to support her. Now, I will skip the part about importance of legal capacity because we have heard about that very much today. But I am going to focus on something else that is very important here, is that we very often, when we talk about legal capacity, we talk about general laws that are either material or procedural that are determining what legal capacity is and where it is applied. And we very often forget that mental health laws also can restrict legal capacity in decision making that is around medical treatment and psychiatric treatment as well. And I will come back later to this point. Now, we have heard today as well where the progress has been made, and I'm not going to repeat that. And there is a certain progress also being made at the level of the European Union and their policies. But while there is a still long way to go, I want to address why it is. Because we have grave dangers coming across. And first of all, I'm going to refer to the European Union. To two laws, and one is the draft regulation that I shortly call it on the cross-border protection of adults. That is, in our opinion, very dangerous because regardless of the intention, and we understand it very much that European Union wants to regulate and harmonize how the exercise of legal capacity happens among member states. However, the provisions that are still referring to guardianship, that are still referring to institutionalization of persons with disabilities, are very dangerous because of the primacy of European law, and it may happen, and that is our grave concern, that member states who decided to make some progress and align their legislations with the UNCRPD will find that they have to stick to the European legislation because they must follow it as the member states. I will show you the example, concrete example. This is the draft regulation we are talking about that may and may not be adopted. But the concrete example comes from the EU clinical trials regulation that was adopted in 2014 and became effective in 2023. What happened in Croatia, that is also EU member state, was that in 2015 the legislator decided to ban non-consensual biomedical research in psychiatry and also against all persons, being made to all persons with disabilities who are deprived of legal capacity. So while the deprivation of legal capacity still standard and the guardianship was still possible, it was banned that anyone who is under guardianship is being placed under the biomedical research of any kind, medical experimentation, without their personal consent. But in 2020, yeah.
I'm sorry, I think we don't see the slides moving, if you are moving them.
No, I'm not moving them. I'm still standing on the slide. So.
Oh, we see the definition one.
It is definition one. Oh, I don't know because I'm moving the slides.
Now it moved, yeah.
Now you move it. Okay, so
now
you see
it's the barriers to exercise of legal capacity.
Now you see me moving slides.
Yes, now it works.
Okay, and then I will keep it like this because obviously the other thing didn't work.
Thank you.
So the clinical trials regulation that became effective in 2023 led the Ministry of Health in Croatia to believe that they can override the ban on involving persons under guardianship in the on subjecting them with the biomedical trials. So they decided to implement the EU trials regulation, and again, after the ban was introduced, now people who are under guardianship can be subjected to biomedical experimentation without their will, without their consent, because this is allowed by the EU clinical trials regulation. So we have a problem that regardless of the fact that Croatia banned non-consensual biomedical experimentation on persons under guardianship, now, because of the EU clinical trials regulation, the Ministry of Health is again approving the biomedical research being done without the consent. The second danger doesn't come from the European Union itself, but it does come from European countries again, and this is in the Council of Europe that is trying to pass the draft additional protocol to the Convention on Human Rights and Biomedicine. And with that additional protocol, the forced treatment in psychiatry, including forced electroconvulsive therapy, including all other forms of forced methods and possibilities of treatment, will be solidified. They will not be approved because many of these already exist among Council of Europe state parties, but if this additional protocol passes, then it will bring also to halting reforms in the European countries that want to go away from coercive practices and want to implement the UNCRPD as well. And this will be international law, and it will bring to the same problem that it was already addressed by validity, that we have different international laws that need to be interpreted with one another, and it will be a question how the progress under the UNCRPD, not only about Article 12, but about other articles as well, in particular Article 14 that is about right to freedom, and Article 17 that is about right to consent to medical treatment to avoid violations of physical integrity as well. It is questionable how these norms of the UNCRPD will be implemented if the countries have other regressive international law to implement at the same time. There is also lack of reforms at national level. We have seen some promising developments, but also, for example, and again in Croatia in 2015, the legislator decided to ban full guardianship, but then later Constitutional Court quashed that and said that it was unconstitutional to prohibit full guardianship. There is also, when it comes to, as I mentioned before, there is also a failure to address mental health laws, because even in countries that have gone far with abolishing guardianship, still mental health laws exist, and they're allowing for forced treatment and forced admission in psychiatric hospitals. Now, I will not go into depth here, about barriers to exercise of legal capacity because we have spoken about that today already, but I will focus on the attitudinal barriers that are very relevant for people with psychosocial disabilities. And there is the first one, it is stigma. There is assumption, especially through medical paternalism and from medical professionals, that people with mental health problems are not capable of making decisions because the mental health problems that they have, like the conditions that I have already mentioned in the introduction, are affecting their cognitive abilities, and therefore they are not able to make decisions. There is also a perception of dangerousness, that people with mental health problems are more dangerous than other people, and that perception also very often leads to denial of legal capacities in a way that professionals usually override will and preference of people concerned, and that they are misunderstanding Article 12. Now we have heard also about what to do to go forward, and I would say, in addition to everything that was already said, we need to abolish or reform mental health laws and ensure access to peer support, advanced directives, and crisis planning. In Mental Health Europe, we advocate for development of community-based services that are based on the model of recovery. There is much that European Union can do, and you can see the big list at this slide here, but I will refer to what Freddy said about having a 20th anniversary of UNCRPD. And I remember when I was a young activist and started working in this field, I was telling everyone, that was 20 years ago, and I was telling everyone, okay, in 20 years, everything will change, we will have so many reforms being done in Europe, European Union will have leadership on this, we will be in much better place than we are now today. But unfortunately, after everything that we have been doing, and after hearing so many times from politicians of all sorts that we are indispensable, that we are the experts, that we are bringing the voice of persons with disabilities, we are having today in Europe regressive laws being adopted or being prepared for adoption, and what we can do about it. It is not a question only for politicians what can be done. It is not only a question for how we talk to them. It is a question for our movement, what can we do? And I am afraid that it is not enough to participate on the meetings and repeat everything that we have been repeating last 20 years. I think that we need to involve much more activism into our work and how we address these issues. And also we must think about strategies, how can we influence the politics in a way that it brings the changes forward and not backwards. On that note, I'm inviting you to support us with our campaign to withdraw Oviedo draft additional protocol. It is the last month of the campaign because it is expected that the additional protocol will come for the discussion at the Committee of Ministers in June, but still there is a chance to try to stop the protocol. If you are interested to support us, you can contact me later, and then I can share you more details about the campaign and how you can help us against that protocol. Thank you very much. I hope that I was under the time of 8 minutes. If you have any questions for me, you can ask me in the chat or contact me later.
Okay, thank you very much, Christian. And now, last but not least, and I think it's the worst place to have being the last speaker of the event. So I will hand the floor over to Pia Lindholm. She's from the European Commission. And please just give your input as thank you.
Thank you. Good afternoon, and thank you very much for inviting me. I have the feeling, and I have been asked to come here less as a speaker and more to listen to you and learn. And I have done my best to do that. I was listening the first part online and then switched in person. Just to note that indeed Mr. Schmidczak said very well that it's very important to have this dialogue, constant dialogue with interested organizations. That is the only way where we get the right input. This event is actually very timely at the moment because tomorrow the Commission will adopt a communication on updating and enhancing the disability strategy up to 2030. It will also be accompanied with a progress report, what has been achieved so far. And secondly, why this event is timely, indeed, Mr. Smichek already mentioned that we are currently negotiating the proposed regulation on the protection of adults in cross-border matters with the European Parliament and the Member States. A few words on enhancing EU's disability strategy. I cannot yet describe the content because it's going to be adopted tomorrow, but I would invite you all to take a look and, of course, give your feedback to the Commission because the feedback is indeed very important to us. There will be some new initiatives and there will be hopefully some very good elements there which you can look into. This is not my work. It belongs to our colleagues in our disability unit because I'm from the Directorate General Consumers, Justice and Consumers in the Commission. But we also have the disability unit in the same service. And we work indeed together with the colleagues and cooperate with them in these matters. And then a few words on the proposed regulation. I don't start describing the content. I think enough has been already said, and there have been many interesting presentations. Maybe just to say a few words about the ongoing negotiations. The final outcome is yet to be seen. So what you have seen so far has been the Commission's proposal, which is already back from 2023. That is always just the starting point for negotiations. It's then the Member States and the European Parliament together which decide what is the final outcome. At the moment, the text is still living and changing. This is typical. This happens until the last moment. But what I can say, because of course the position of the European Parliament is public information, and so is the Member States' position, the Council General approach, that there is a clear trend in both towards more modern language, more support language, more UNCRPD-inspired language. So this is visible in both the opinions. There is even more in the Parliament's position, but it is even in both of them. And I would say that both the Parliament and the Member States, they share the same commitment to create the best possible framework, also in full compliance with the UNCRPD. And just a few words to recall that I know this is not always well liked when we explain that the EU is not a state and we don't have the same powers as a state. We have just the powers the Member States have given us in the treaties. And Member States are also very strict that we don't go beyond these powers. So this is a reason why there are certain limits, what we can do and what we cannot do. So certain things still belong to the Member States' competence. This is, of course, not to say that we cannot do anything at all. There are still plenty of things we can do. So maybe a few words about forward-looking, about the future. I would be joining Freddie's very positive and forward-looking approach. First of all, of course, implementation of the disability strategy continues, and we will indeed try to enhance it. You will see tomorrow the implementation continues. We try to improve. And once the regulation has been adopted, hopefully soon, we will monitor its implementation and application. There will also in the future be guidance training that has been mentioned here. Once the regulation has been adopted, it will be among the elements of European judicial training. So there will be training for judges and other court staff also, how to apply the regulation, also in light of the UNCRPD, of course. There is funding available, so just to advertise a little bit also that please remember that there is also EU funding available, which you can apply under various programs. So please remember to apply. We need good and relevant projects. And then the call to you, which Freddie already mentioned, so continue your advocacy work in the member states. That is indeed the way to make things change at the member states level. We have certain limitations, what we can do, but then you can do a lot more at the national level. And now I think that is all I wanted to say. Thank you for your attention, and I will indeed share all the information I have received this afternoon with the colleagues in the Commission. Thank you.
Thank you very much. And thank you. And we will definitely continue to remind, as well as the European Union, as the member state, that they all ratified the convention and that they had their obligation under this convention, and remind them about this, to keep it in line with all the reforms that are on the table. And yeah, like you all can see, we are lack of time to open the audience for questions and answers, but we bombarded you with a lot of information. It's, for me anyway, the first time that we had so many different kind of stakeholders on the same topic, on the same afternoon. It was a lot. We bombarded you maybe with a lot of information, but that should engage us to tell you, bombard us with your questions. We will follow this up. It's not because we don't open for question and answer right now that you will not work for it. Tomorrow there will be the next European Disability Rights Strategy that will be open. We will see what kind of commitment the European Commission is going to undertake, what kind of action will be in it. So we will group your questions and all the new policies that are in making of, and we will definitely come back to you to follow this up. This is just to begin, I think, and we are in a crucial time. So impact may be still worth it to try. If we unite our voices and our strength, I think we will manage to have at least some visibility on trying to change things on these new reforms that are on the table on the Hague Convention. I give maybe the floor now also to those who are behind the preparation, all of this. Florian, you can take the floor for some minutes if you want, and just share with us the next steps from. We are over it. Yes. It's the, so I don't know how long people from the captioning can stay with us.
And we don't hear you there, Florian.
Okay, sorry. Florian was proposing, yeah, go ahead.
Yeah, we are wondering maybe if we should allow just a couple of questions from the audience, because yeah, we're out of time, but we are allowed to stay until in the room a little bit longer. So what does the moderator say?
It's
the moderator.
The captioning provider. Will you be happy to stay with us till 10 minutes, if that's possible? At least to receive some question, and then we can still follow up. But this doesn't mean that you cannot send us your questions, please. Please do. Because this is the opening for the dialogue. We need to have that dialogue with all of you. Oh, the floor is open. If the captioning is okay.
Okay. Shall we start with a question for here the people in the room? Any questions, comments? Everybody's talking.
Please.
Okay.
And those online, please write down in the chat if you have any question. Yes, please.
I am.
Present yourself shortly.
Yes, of course. Max, I'm from the St. Lazarus Foundation, which is based in Malta, but it's an international organization. We work with several initiatives related to disability, and I want to congratulate you, Madam Chairman, for your handling of this conference. It was a big list of speakers, and you did well to try and summarize and maximize time. So congrats. Just a couple of points. Unfortunately, we're talking here about a lot of initiatives which need to be done country by country. So although everybody speaks on the possibility of unifying and codifying the same legislation, it is impossible, and we know that. My colleague from Malta mentioned the 2026 legislation, which will be passed in Malta. What he didn't mention is that legislation is being passed from the ministry related to inclusion. But then there's the ministry related to social welfare, ministry related for health, the ministry related for justice, the ministry, if you're in Gozo, this is the island, there's the ministry for Gozo as well. If you're of studying age, there's the ministry for education. And if you're working, there's the ministry for employment. And trust me, because we lobby this every time, the problems between ministries in the same country is something which also impedes the progress of what we are all working for here. When it comes to European Commission, yes, you were right in a lot of points you mentioned, but you mentioned dialogue and funding. I have personally seen institutions in European Union countries which were funded by EU funds, which totally are against what we were talking here. Nothing was done to reduce EU funding. Nothing was done to change and implement positive changes in these institutions, and they are still there today, a disgrace to humanity. I don't want to mention countries for obvious reasons, but they're still there, and they were done by EU funding. And obviously, you have to lead by example. As you all know, in December, there is the European Commission Conference on Disability. And every 5 years, for these last 10 years, I have always asked the same question. How many employees are employed by the European Commission who are disabled? Employees are employed by the MEPs who represent all our countries. Trust me, the numbers are insignificant. So we have to lead by example, because paperwork is great. Everybody loves it. But at the end of the day, we make a bonfire with paperwork, nothing else. Thank you.
Thank you very much for your intervention. And indeed, we need to work intersectional on an intersectional also. For persons with disabilities, like you said, they are working in different areas. With the ministries also, we need a holistic approach. And that's why whenever we speak about independent living, don't only have the 18 pillars of independent living, it's much wider and much vaster. And so we need to have big metrics. The metrics needs to be done on national level or neighborhood level, and then also bottom up. It should go from both sides. And that's only possible if people understand this, work through this, and work together, and that we create a society for whole. And without this, and without screening the money and bringing the human, technical, and financial resources to this, it won't be possible to realize it. And so they keep us busy, reminding ourselves and other people to walk through this direction. Thank you very much for all of you for being here today, for your time, for your energy, and for, I hope, your solidarity and your goodwill. Not only goodwill, but your engagement. we should speak about engagement to follow this work up. Thanks a lot.
Can we still allow a question from one?
Yes.
He's gone? Oh, okay. Never mind. One participant has been asking to take the floor like for 4 hours. So we wanted to give her the opportunity, but she has left. Okay. It happens.
Thanks a lot. Thank you for all the participants online. Thank you for those who support the team of ENIL, each of you, volunteers, and all of you who attended this meeting and make it, for me, a success, because we had more than that at a certain moment, 50 people online. I know you're here inside, so that's a good way of celebrating the Independent Living Day. Thanks a lot to all of you. Bye, everybody.
Thank you all. We will also stop the recording and close the Zoom. Thank you for joining. So, this is the stop.